A Sarkari exam must always be prepared in a Sarkari manner. And the two absolute truths to civil services preparation happens to be the syllabus and the previous year questions. The syllabus becomes your starting point and it answers two basic things: what is written in the syllabus, what is not written in the syllabus, and on the basis of these two things you can figure out what is indirectly in the syllabus and what is indirectly not in the syllabus. As far as previous year questions are concerned, they answer three very simple things. What did the UPSC ask? When did it ask so? Why did it ask this? On the basis of this, we can correlate it to contemporary developments, repetition quotients, relevancy, and we can understand what is the most likely question in the next cycle. So the purpose of this video is a very simple one. The last 10 years of previous year questions from Polity, GS paper 2, mains, analyzed thoroughly in one place. Thank you, and I hope you make the most benefit out of this video. When I look at the syllabus, the words preamble, fundamental rights, directive principles of state policy, and fundamental duties, none of them are actually specifically mentioned in the syllabus, which means they are not explicitly mentioned in the syllabus. Does that mean we ignore them? Of course not, because they are vital to understanding polity and the constitution in general. This means that they are implicit as far as the syllabus is concerned. If they are implicit, then we must also understand how exactly are they implicit. First things first, there is something called important features. Then there is something called significant or important amendments. Then there is something called the doctrine of basic structure. And on the explicit front, you will find basic structure mentioned, and you will also find separation of powers mentioned, wherein basic structure, translating into judicial review as one of the components, has a key impact on separation of powers and thereafter checks and balances. So although a topic which is not explicitly mentioned in the syllabus has four correlations to our syllabus, and therefore we have to make sure that we do this in the appropriate manner. So this particular set of four topics is both implicit and explicit. Explicit on two counts: one, basic structure, and two, applications of separation of powers. Implicit on two counts: important features and important amendments, because some of the most significant constitutional amendments are actually owed to preamble, rights, directives, and fundamental duties. So we shall keep that in mind. Now, we will cross-reference it with PYQs and we will see whether or not they've been asked because of a certain reason. We'll also check how frequently they're asked, and we'll also check to what context are they asked. And to answer this more carefully, we will cross-reference it with current affairs and check, was something that occurred in the same year as the mains calendar or a year before the mains exam triggered that question to be asked? Was it something which was generally in the news for a longer time, or we were celebrating an anniversary or a monumental year of 5, 10, 15, 20, 25-year-old anniversary, which is why it sort of becomes important. So we shall keep that in mind, and we will therefore draw a relevancy matrix or a topic relevancy shortlist, which we will follow. Now, this particular lecture will have to be divided into two parts because there is a significant amount of things that have to be covered, largely because on an average, you see anything between 1 to 2 questions being asked from here directly in the mains exam. And not only this, some of the key learnings from these topics are correlationally important to your other GS papers and also contextually important to your essay. So this in fact happens to be one of the most open-ended and also happens to be one of the most diverse areas that we have to cover. देखो कहने की बात यह है कि ये एक बहुत ही हाई रिवॉर्डिंग टॉपिक है. ये हमें पता है कि 1 से 2 क्वेश्चन तो आएंगे ही आएंगे, और एक क्वेश्चन अगर बेसिक स्ट्रक्चर से है तो दूसरा राइट्स इशू से भी आ सकता है, और ये कई बार आया भी हुआ है. बट इसके अलावा क्योंकि राइट से राइट्स इश्यूज निकलते हैं, वो आपके पेपर 1, पेपर 2 तो हम कर ही रहे हैं, पेपर 3, पेपर 4 और एसए में भी बहुत काम आते हैं. Which means we have to be a little precise, we have to be a little more comprehensive at the same time to cover what is to be relevantly done as far as the mains exam is concerned. So let us look at what kind of questions have been asked. थोड़ा इसको आराम से करेंगे, थोड़ा ठहराव से करेंगे. Not because of anything else, because if you also learn the science of PYQ deductions, so you will be able to apply it to other subjects, you'll also be able to apply it to other papers, and you will also be able to cross check whether what we are doing is actually making sense or not. So it works in multiple number of ways. Now, there are 4 topics: preamble, rights, directive principles and duties. And we've understood that these 4 topics are asked directly and indirectly, standalone and otherwise. So let's break them up and let's look at first the preamble. Now, in the last 10 years, there has just been about 1 question from the preamble, and that was in the year 2016. And the question categorically stated, it's right up here: discuss each adjective attached to the word republic in the preamble. Are they defendable in the present circumstances? Now, the first mistake most people would do is they would not read attached to the word republic, which means if you look at your state-centric adjectives, it is sovereign, socialist, secular, democratic, republic. What the exam is asking you is only sovereign, socialist, secular, democratic, but not republic. The trick part is, are they defendable in the present circumstances? Which basically means, are we sovereign? Are we socialist? Are we secular? And are we democratic? Of course, this could be answered in a fairly good manner. There are enough and umpteen examples that could be given. Basically, this question has to be done through a subdivision method. A simple subdivision method is break the question into smaller questions. So you'd say, for example, sovereign, the original meaning, the transition of the word sovereign, the updated meaning, the reasons for transition, and what does sovereignty mean for India in the contemporary context, which would, for example, mean national interest. We would cover something simple, similar to this in Magna Carta Mains 2024, and I'll tell you why. So let's first look at why this question was asked. Now, the preamble has had 1 amendment till date, and this amendment was done in 1976, and the UPSC loves their anniversaries. So 40 years to the 42nd amendment of 1976, you had a question on the preamble. Now let us apply it and see, is this relevant for mains 2024? So irrespective, because you have such an interdisciplinary usage of something like the preamble, maybe a direct question on the preamble is unlikely, but having a 1-pager covering the legal status and the utility and meanings and applications of key terms will not hurt. And if they can ask you the preamble, they can also ask you a stand-alone question on What is the utility of directive principles? Why do we even have fundamental duties? Do they make any sense? They probably give you a quote around it and ask you to explain the quote. So, not the most important, but should definitely be done. So we will do this in lecture 2.2. We're on lecture 2.1. It's not highest priority, but just to keep our boxes tick, we will definitely do this in lecture 2.2. Now, that's pretty much it as far as the preamble is concerned. Now, we move to fundamental rights. Here you'll be able to make a lot of very, very educated deductions. Almost every year, barring maybe one or two odd instances, there has always been a question on fundamental rights. So in 2013, the question was, discuss section 66A of the Information Technology Act with reference to its alleged violation of Article 19 of the Constitution. Now the reason why this question was particularly asked was, section 66A was in the news in a transient form because of certain very, very questionable instances. There were two girls who were arrested in Bombay because of an objectionable post that they had made on Facebook back in the day, and Facebook used to be cool. The post that they made was regarding the shutdown in the state of Maharashtra because of the death of a very, very well-known political leader in the state of Maharashtra called Bal Thackeray, and therefore they were arrested under provisions of section 66A of the IT Act. In continuation of that, Asim Trivedi, if I'm getting the name right, was a very well-known cartoonist who had made certain political cartoons and therefore was arrested under grounds of section 66A, and the judgment was pending. And even if you today don't know when the judgment was, if you read the text of the question, it tells you with reference to its alleged violation, which means the question is not being asked post the Shreya Singhal judgment. So this teaches you 2-3 very important things. First, Article 19 is a highlight. 2, if the Supreme Court judgment is pending, that means your opinion on the issue would be asked. If the Supreme Court judgment has been delivered, then generally your impact is asked. I will prove this theory when we look at the right to privacy question of 2017 just in a few moments from now. And that teaches you a very, very important insight. So this is the question. Thirdly, and very importantly, while the context can be political or controversial, the question rarely ever is. The question is going to be very straightforward. You're supposed to answer an apolitical and a neutral answer to a question which has been inspired from politically anxious circumstances. And the idea therefore is to test your ability to write an answer as a well-informed citizen of this country. So while trigger events such as these can prompt a question like this to be asked, the question will never be on the trigger event. The question will not be ever on that specific political issue. And that's a very, very important insight to have, which is also why you've never been asked your opinion on reservation. You've never been asked your opinion on something religious. You've generally been asked an academic question, never a question on a specific incident which was controversial, political, or objectionable in nature. So we'll keep that in mind. Now, 2014, that itself gives me a heads up that it is an election year. Now let us read the question carefully. What do you understand by the concept freedom of speech and expression? Does it cover hate speech also? And why do films in India stand on a slightly different plane than other forms of expression? Now, there is too much being asked, but there is a common thread to it all. Of course, the first thing being it's election year. But always remember, the longer the question, the easier it is to structure the question. It is easy to structure a question because the structure to the question is already mentioned in the question. Even if you divide your question into three parts and answer, first heading, meaning of speech and expression, second, relationship with hate speech, and third, treatment of films, that itself is a fantastically brilliant structure which is absolutely good as far as the examiner is concerned. And now when you look at the reason why this question was asked, it's even more enticing. There was a lot that was going on. First, of course, as we mentioned, it was an election year. Second, election years are infamous for questionable speeches. Questionable speeches that often tend to cross the line. Questionable speeches that can often be very dangerous in terms of caste or religion. And when the speech is targeted to a specific community, that form of speech is called hate speech. Now, hate speech instances will always rise up in and around elections, whether it is a national election or a state election. But generally it is national election which brings hate speech into the forefront of things, which is why it's asked in the context of what is called the election year. But also, just a few months before, you had also suffered from what were called the Muzaffarnagar riots. At least in the past decades, in the past decade or so, not decades, at least in the past decade, Muzaffarnagar riots have been one of the deadliest insults to law and order and civic behavior in the country. And therefore, the reason Muzaffarnagar riots happened, and they were communal riots, were because of certain inflammatory speeches that were delivered which had an impact beyond imagination. Thirdly, it also celebrates approximately 100 years of Indian cinema. The first silent film goes back to that date. And the censor board was brought into the fray of things because of very, very questionable decisions it had taken on a film which was very well liked and had in fact a lovely message embedded in the film. The film was called PK. And at the back end of things, the leadership of the censor board was undergoing some changes in terms of appointments which were allegedly to be biased for the ruling dispensation. And also the censor board, in terms of its functioning, was also questioned by the CBI for the lack of transparency. So one could definitely say that this question had a trigger event. This question had a floating issue of the censor board, the trigger event being the hate speech. And at the very same time, this question very categorically never ever mentioned the instance, but asked you to answer this question rather apolitically. And if you see, the thread continues. We are still on Article 19. You have still been asked an apolitical question out of a political or a controversial issue. And at the same time, you've been asked a question in a purely academic fashion. So by now, we can very categorically determine that Article 19 is indeed a UPSC favorite. And especially during election year, which automatically makes it a sort of a green flag for us as far as Mains 2024 is concerned. Now, 2015. Does the right to clean environment entail legal regulation on burning crackers during Diwali? Discuss in light of Article 21 of the Indian Constitution and judgments of the Apex Court in this regard. Now, after 2 years of Article 19 questions, we see an Article 21 question. Now, the judgment has not been delivered yet, which is why you have been asked your opinion on this pending Supreme Court judgment. It is in this very judgment, by the way, where the Supreme Court has actually given out a clear-cut direction and a clear-cut set of regulations which said that we will not outright ban crackers in Delhi, but we will impose a very high degree of terms and conditions on how crackers are to be burst in Delhi, which basically means crackers beyond the decibel value are not permitted. Crackers which cause pollution beyond a certain limit are not permitted. Crackers beyond a certain time limit are not permitted. And this essentially creates a conflict within rights. And conflicts of rights between each other is a UPSC favorite. So on the one hand, you have the right to a clean environment, which has also been sort of derived by the Supreme Court as an interpretation of Article 21. At the same time, you have the right to life, and you also have the right to celebrate your own festivals as an extension to that right to life. You could also implicitly put in a little bit of Article 25, because if people are burning crackers during Diwali, it is also one of the ways that you are in fact celebrating a religious festival. And it's not just during Diwali that crackers are burst. In fact, crackers are burst across different festivals, across different religions. So the idea here is, this was in the news a couple of months before the mains. The judgment was pending, yet was important enough to be in your mainstream newspapers for us to be a little careful about. So now, in addition to Article 19, Article 21 becomes a UPSC favorite, and we'll see how in a few questions from now. And we started with a thesis which was that if the Supreme Court has delivered a judgment, then what you would be asked is the impact of that judgment. What you would be asked would be the consequences of that judgment. And you're able to see this categorically in 2017. And in 2017, the question is, examine the scope of fundamental rights in light of the latest judgment of the Supreme Court on the right to privacy. And this is, of course, the Puttaswamy versus Union of India judgment of 2017. Now, the judgment was delivered before the mains exam, which means you're not going to be asked whether you think right to privacy should be a fundamental right or not. The question is very categorical on this. The question asks you, now that we have right to privacy as a fundamental right, what do you think it will lead to? What are its impacts? And therefore, you would look at its impacts on informational privacy, on data privacy, on body privacy, on physical privacy, on financial privacy, and so on and so forth. The fact that we have right to privacy as a fundamental right itself becomes a catalyst for several socio-legal reforms. In fact, one of the primary reasons why we were able to decriminalize homosexuality in the Supreme Court judgment of Navtej Singh Johar versus Union of India is because the petitioners were able to argue that now that we have the right to privacy, and bodily privacy is an integral element of privacy, we would like for people of the same gender to be allowed to be intimate in a private sphere nonetheless. And it would therefore be arbitrary to have sexual orientation as one of the grounds preventing people of the same gender to be intimate in a private capacity. And therefore it is not just arbitrary, it is also not reasonable, because it violates the principle of intelligible differentia and rational nexus and intelligible differentia. So therefore, the fact that the judgment has been delivered makes this actually a law and a policy question. And of course, it's Article 21. So up until now, we've got two questions on Article 19 and we've got two questions on Article 21, which means you have to prepare 19 and 21. And if you see, there is a certain repetition, sort of a frequency matrix. If they've asked this 2 years, then they'll skip and they'll come back after 2 years. This will help us a lot, because in 2023 and in 2022, there were a bombardment of questions directly and indirectly on Article 21, which means Article 21 for us in 2024 will be of a slightly low priority than perhaps Article 19. So we'll keep that in mind. And because of the fact that 2024 is also an election year, also notorious for certain elements related to speech and expression, Article 19 becomes all the more important. So for 2024, to the best of my understanding, Article 19 would therefore be more important than Article 21 because of frequency, because of context, and because of dimensions. So we must keep that in mind. Now, if you take a moment and just look at the questions before you, you would also understand that from a theoretical point of view, none of these are dimensions that you would have not thought of. When you do Article 21 theoretically as a part of your foundation courses, or when you study it on your own, when you're preparing it, not right before the mains exam, but generally for UPSC, you would have prepared privacy and you would have prepared environment as two of the most important aspects of Article 21. Similarly, when you study Article 19, censorship and forms of media and dissent related issues such as protest, strike, hate speech, and sedition, which now today is far wider and far deeper because of Section 150, 156 of the new IPC, where punishments are also a little more strict, which has just come into effect from the 1st of July 2024. But these are very legitimate, very, very logical and very, very theoretical boundaries to Articles 19 and 21. So we must keep that in mind. Now, 2019. This is where there's a little bit of sprinkling of comparative constitutional law. Now, comparative constitutional law has been asked twice with respect to this topic. One has been with France and secularism, and the second has been with US and equality. So, in fact, when I look at a syllabus correlation, I also understand that there must be some reason for me to be very, very careful about when it comes to comparative constitutional schemes. But comparative constitutional schemes have to be prepared with a very high degree of context when it comes to these topics. Let's understand why that is the case. So, in 2019, the question was, what can France learn from the Indian Constitution's approach to secularism? First, you've identified France. Now, secularism, of course, is in the preamble, is reflected in fundamental rights, also has intersections with directive principles in the form of Uniform Civil Code, and also has some reflections in fundamental duties in terms of having a scientific temperament and, of course, living in harmony and so on and so forth. Now, why France and why 2019? As you would know that France had banned women of the Islamic faith in France to wear something called a hijab. Now, the burqa is an all-body outfit, whereas the hijab is something that covers the face. Now, under Islamic faith, Islamic women who are ardent followers of the Islamic faith tend to keep the hijab. Now, the French government, some time ago, before 2019, had actually banned the hijab. Now, what happened in 2019 was, they made an amendment to the hijab law and therefore said that women who are mothers accompanying their children, even for school trips, will therefore not be allowed to wear a hijab. And this became a rather questionable exercise, because if your grounds for banning the hijab was security, a mother accompanying her child on a school trip cannot be a grave security concern to begin with. So that caused a lot of protest. Second, though this was incidental in nature, but one of the most well-known landmarks in France, called the Notre Dame Cathedral, was also burnt. Now, it was not done because of communal reasons, but it was incidental in nature. But it is also around the same time that several Jewish temples in France were also attacked. Now, if you look at it, there are basically three countries that we get asked questions on. We get asked questions on US, UK, and France. Now, 2019 teaches you something very important. There has to be a context, and there has to be a significant comparative difference. When we look at the models of secularism between India and the West, when we look at the debates on secularism between India and the West, France tends to be that country which has dealt with secularism in a very, very unique way and in a very stark way as compared to how India has. The Indian version of secularism and the US version of secularism are, of course, very different, but are not as poles apart as what India and France is. So, therefore, if secularism had to be asked, A, there had to be a global event around it, and two, the country that you would naturally ask a question on secularism would be a country called France. And that is why in 2019 there was a question on secularism and France. Now, this is a comparative constitutional question. You have to know a global event. Now, let's take a minute here and think. In 2024 and perhaps the second half of 2023, there hasn't been a major global rights movement. There are two major issues that have come to the limelight, and that's been from the US. One has been an issue of how the US, through the Supreme Court, has scaled back sort of racial affirmative action exercises, basically reservation for African Americans at higher educational institutions in the US. And two, the US has also scaled back its stance on pro-abortion rights. Now, pro-abortion rights are too specific to be asked. Even comparing gender rights between India and the US is too specific to be asked. And the last question that was asked on comparative constitutions was between India and the US on equality. And affirmative action is an aspect of equality. In fact, what we have is called, the form of equality that we have is called egalitarian equality. It's a combination of substantive equality and formal equality. And our notions of egalitarian equality, which combines the principles of equality, equity, and justice, are in fact one of the finest in the world. But that's besides the point. The point is, the US was just asked, and the question was on equality. So even if there has been a major issue with rights pertaining to equality in the US, it still doesn't make it relevant enough for Mains 2024. And that's the kind of discretion, and that's the kind of a hard footing we must operate on, because A, time is finite, and B, memory is even more finite than time. Now, in 2021, analyze the distinguishing features of the notion of equality in the constitutions of US and India. And this is, of course, applies the same logic in the context of the Black Lives Matter movement. Now, for a question on gender and affirmative action to be asked again in the context of US seems extremely unlikely, especially in Mains 2024. So therefore, as far as Mains 2024 is concerned, and if you think about it the other way, we're in fact witnessing elections in the UK. We will be witnessing elections in the US, which means there has to be one question on comparative constitutions. And if there has to be one question on comparative constitutions, think like the paper setter. Would you rather not have a question comparing presidential and parliamentary systems like you asked before? Or comparing parliamentary differences between the UK and India? Because of course we are a model, but we are also distinctively different from the way the UK operates. Given the fact that all the three of us have elections on our plates. We've just finished ours, UK is in the process of theirs, and the US is going to get into elections in a few months from now. So for these very reasons, if there's going to be a comparative constitutional law question in Mains 2024, it's going to largely be on political systems and their differences between either India and the US or India and the UK. So we'd rather prepare that than to waste our time on comparative constitutions as far as rights are concerned. This is a very logical way to go about it. Now, 2022. So equality is Article 14, 2022. The right of movement and residence throughout the territory of India are freely available to Indian citizens, but these rights are not absolute. Comment. Again, we see Article 19 as a showstopper. We again see a completely apolitical theory question. And let's understand why this question was asked in 2022. 2022 is where we've been in the midst of the pandemic. We've seen multiple waves coming in. And one of the first things that you would do when the country and the world hits a pandemic is enforce a lockdown. And when you enforce a lockdown, and we did that under provisions of the Disaster Management Act and the Epidemic Diseases Act, and one of the first things that you would do is enforce a lockdown. And this would directly impact your freedom of movement. On top of this, because of heightened protests in and around developments with respect to the Citizenship Amendment Act of 2019, and of course the farm law protests which were at its peak, where you had almost seen an instance where the National Capital Region of Delhi was chock-blocked from all four corners, preventing any exit or entry from Delhi, almost making the capital come to a standstill, with of course excessive violent protests reported in and around and inside Delhi, which would of course lead to certain curfews, certain provisions of the CRPC which will now be revamped to be put in place. And also at the same time, you are also witnessing the Assam-Mizoram border dispute. Now, this is triggering, but at the same time, it is floating. There were a series of isolated events all through 2024 which led the government to enforce restrictions on the movement of the people. As a result of this, you had to therefore invoke provisions of Article 19. And that is why the question in 2022 was asked. And again in 2022, environment has been asked before, and environment has been asked in the context of 21. We see an environmental question again in 2022 pertaining to Article 21. The question is, the most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss this statement with the help of relevant case laws. Now, this is an anniversary question. And whenever there is an anniversary question, the question will always be very reflective in nature. The question will always be very encompassing in nature. The question will ask you to sit back and think, are we happy where we are today? How did we get here? Has it really helped? What has generally been the state of evolution? Now, environmental law in India is generally understood to be reactionary in nature. In fact, most of the doctrines that we have evolved in environmental jurisprudence have been because of Supreme Court judgments. Which is why, after the Stockholm Conference in the 1970s, the Bhopal gas tragedy is often considered to be a watershed moment in environmental jurisprudence, which eventually led to the Environmental Protection Act. But whenever you look at some of the core environmental doctrines that have been evolved, they have always been evolved by the Supreme Court. In fact, environment has played a very significant role, not just in environmental jurisprudence, but rights jurisprudence in general. It is because of evolution of the rights of environment, you see a wider meaning of Article 21. You also see an enhanced usage of public interest litigations. You also see usage of the Supreme Court's powers to take up cases suo motu. You also see fundamental rights which are traditionally available only and only against the state to also be available against private institutions because they are the chief polluters of the environment. And fourth, of course, you see the conceptualization of certain environmental doctrines. Now, these environmental doctrines, as we understand them to be, are, for example, sustainable development, polluter pays, the precautionary principle, the public trust doctrine. And all of them are credited to a very select few number of environmental cases. We've had very few public-spirited lawyers who have constantly filed cases after cases in almost the same amount of time, thereby leading to a same 25-35 year plus minus one anniversary setup. Which is why MC Mehta, Vellore Citizens Forum, Rural Entitlement Kendra, they're all in the 25-35 range. Which is why in 2022, there was a question on environmental jurisprudence. Now this means it is very close to 2024 and we have a frequency pattern to keep a note of. And if Article 21 appears in 2023, which it will, it automatically reinforces the idea that we don't have to do it any more further as far as 24 is concerned beyond the basics. So we'll remember that. So 2022 is again environment aspect of Article 21. Now, 2023. Two questions, very open-ended, but again, for very simple reasons. The question is, the Constitution of India is a living document with capabilities of enormous dynamism. It is a constitution which is made for a progressive society. Illustrate with special reference to the expanding horizons of the right to life and personal liberty. Now, one of the first things I request you to do is, don't get afraid by the framing of the question. Always look at polity as a comprehension English exercise, where your job is to simplify what the question has asked. The Constitution is a living instrument with capabilities of enormous dynamism simply means the Constitution is capable to change. The Constitution is flexible. The Constitution can evolve. And the Constitution is made for a progressive society means the Constitution evolves keeping in view the changes in the outlook and the aspirations of society. Illustrate with special reference to the expanding horizons of life and personal liberty. Now in 2023, the reason why this question was asked is because the most significant judgment which had an enormous impact on Article 21 was also a slightly odd question in 2023 in the prelims also, was Menka Gandhi. Because in Menka Gandhi versus Union of India in 1978, what had basically happened was, the Supreme Court said that though Article 21 says procedure established by law, it also, through an implied meaning, includes what is called due process of law. Now, what the Supreme Court meant by due process of law in Menka Gandhi's case was procedural due process. So, Article 21 included life and personal liberty which could be restricted by procedure established by law. Because of Menka Gandhi, the Supreme Court interpreted it to be due process of law, but from a procedural standpoint, which means not only should the procedure be valid, the procedure must also be good. And for you to check how the procedure has to be good, you would apply the principles of natural justice. This was 45 years ago in 2023. And that is why this question was asked. So this question basically gave you an open hand to tell me how exactly has Article 21 evolved over a period of time. Environment, right to life, therefore means right to dignified life, therefore means right to death. It also means due process of law. It also means privacy. It also means a host of other things. So the idea, you could organize it in a certain way. You could take life, give me interpretations of it. Personal liberty, give me interpretations of this. Do a thematic understanding of environment and privacy all over again. And throw some light on due process of law. And that's your answer for 2023. The longer the question, the easier is your structure, because the structure is embedded in the question. So this was why 2023, again, an anniversary year, therefore had a reflective question. So 2024 should be an anniversary of what? The greatest judgment which comes to light in 2024 is S.R. Bommai of 1994, which has nothing to do with fundamental rights per se. Has an implication, but nothing strongly to do with fundamental rights. It's a combination of a host of other things, including emergency and federalism. We're witnessing 5 years to Sabrimala. We're also witnessing 10 years to the Nalsa judgment. But both Nalsa and Sabrimala have a very limited capacity to be asked, and I'll show you how. Simply because in 2023, if you read the question, explain the constitutional perspectives of gender justice with the help of relevant constitutional provisions and case laws. Now, if this question has been asked, that means there has to be a trigger event, again an anniversary year. Basically, 5 years to the Triple Talaq case, the Shaira Bano case, and Uniform Civil Code in 2023 was also in the news because of certain speeches that were being made, and there were also talks about several states pulling in and therefore thinking of coming up with the Uniform Civil Code. In fact, the Uniform Civil Code is also important this year because Uttarakhand has tried to enact one, and therefore there will be some amount of importance on that front. Having said that, there has been a question on Uniform Civil Code when we were celebrating X number of years to the Shah Bano case, and I will discuss that question under the DPSP section, but mostly because of anniversary years. So we have to keep a track of these things, which of course we are as far as your Mains 2024 is concerned. Now, this question in 2021, I know 8 out of 10 students who attempted this purely from a fundamental rights perspective. Rightfully so. But remarkably, this question, although is about fundamental rights, but is also about so much more than fundamental rights. Constitutional morality is rooted in the Constitution itself and is founded on its essential facets. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. Now, why would this question in 2021 be asked? And this is a cumulative question, which is why I kept it as a special question later. Because A, petitions were filed challenging the amendment to the Citizenship Act of 1955. The amendment was made in 2019. A petition was also filed challenging the abrogation of Article 370, which has now been decided by the Supreme Court in 2024, and the abrogation of Article 370 has been upheld by the Supreme Court. Petitions were also filed to entertain a review of the Supreme Court judgment on Sabrimala. And there were also issues of a federal conflict between the Lieutenant Governor of New Delhi and the elected government of Delhi headed by the Chief Minister. And all of these things have constitutional morality in common, as argued in the courts, as discussed in the courts. See, constitutional morality has two aspects to it. One, where in the Constitution is the word morality explicitly mentioned? To the best of my memory, the word morality in the Constitution is mentioned in 4 places. Twice under Article 19 and twice under 25 and 26. So constitutional morality therefore means 2 things. One, where in the Constitution is morality explicitly mentioned and how? And in all the 4 places, morality is mentioned as a reasonable restriction to fundamental rights. And secondly, even though in places morality is not mentioned, the Constitution itself is a moral document. So if the Lieutenant Governor of Delhi does not want to listen to the advice of the Chief Minister of Delhi, who's heading a democratically elected government, you are violating the very moral compass of the Constitution that it set out to be, which is effectively to empower parliamentary democracies. So that is the context. Anyway, 2023 was also an Article 21 question with a little bit of Article 15 involved, but primarily an Article 21 question, which is why in 2024, if there has to be a dedicated rights question, given the fact that it's an election year, given the fact that speeches go haywire, you should be looking at an Article 19 question in Mains Exam 2024. Because aspects of privacy, evolution of Article 21, all of that has been asked rather too recently, thereby making Article 19 the flag bearer for core fundamental rights for Mains 2024. Now, some special questions. We've discussed constitutional morality. This question, though has origins in fundamental rights, but actually is a bodies question which has intersections in governance and polity and social justice all together at the same time. Let us understand how and why. In 2018, the question was whether the National Commission for Scheduled Castes can enforce the implementation of constitutional reservation for scheduled castes in religious minority institutions. Explain. Now, if you think about it, the question is actually not about reservation. The question is about the mandate or the powers of the National Commission for Scheduled Caste. And the reason why this question was asked in 2018 was because both of the religious minority educational institutions which are centrally funded, the Aligarh Muslim University and the prestigious Jamia Millia Islamia, both had denied reservation to students of the SC community, as an outcome of which petitions were also filed. So this question was not about the idea of reservation, and our original thought remains to be the same. While reservation is a contentious issue, while reservation is a controversial issue, while reservation often realms into a political arena, the question that has been asked is still an apolitical question. And the question largely pertains to the mandate of the National Commission for Scheduled Castes more than anything else. And that is why it becomes more important than anything else. Now, let's remember this as we move ahead. So, if you recollect a little bit of current affairs, you would recollect that the Supreme Court has finished hearing arguments about the case concerning Aligarh Muslim University as to whether Aligarh Muslim University is a minority institution under Article 30 and what are the parameters that should be made to determine whether an institution is a minority institution. Now, this case is originally titled as Faizan Mustafa versus Union of India. Faizan Mustafa, as you would know, is a very, very popular writer and a very popular legal personality. He happened to be the ex-vice chancellor of the Nalsar University of Law in Hyderabad. Of course, runs a legal podcast series and is very, very popular amongst the youth of this country. And he's also currently serving in an administrative capacity at the Aligarh Muslim University. So the case is filed on his behalf. But it is a Supreme Court case. The Supreme Court case is pending. The judgment has not been delivered yet, which means you can be asked an apolitical question on religious minority institutions or minority educational institutions or linking National Commission of Minorities to minority educational institutions and the larger scope of Article 30 if need be, therefore making it a green flag. Because in the news, judgment is pending, there is a prior occurrence of a similar question. Would you be asked a question on Aligarh Muslim? No. You would be asked a question on minority institutions or religious minority institutions or religious minority educational institutions. Either of them make perfect sense. This is why, ladies and gentlemen, it is very important for us to get our PYQs right, because through this, we're able to identify certain key topics. So, as a result of this, what are my factors that I'm considering? I'm considering anniversaries of judgments. I'm considering anniversaries of important constitutional amendments. Articles 19 and 21 are my showstoppers. Important Supreme Court cases in progress. Important human rights issues in US, UK and France. And of course, there is election year context. This cross-referenced with dimensions and frequency of PYQs leads me to these outcomes. So, from core fundamental rights, I need to get minority rights, I need to get property rights, because postal bill, telecom bill, a bunch of these were in the news. Just for safety purposes, digital rights, because Uniform Civil Code was in the news, UCC, because the Supreme Court has delivered a bunch of judgments last year and this year in and around the aspects of right to life. So a larger discussion on right to life, specifically just to be on the safer side, though not very important, still should be done. Article 14 fundamentally has to be done because Article 14 has been asked in the last 5 years, and a theoretical understanding of Article 14 just as the one pager to keep our ourselves safe. And then because it's election year, press freedom therefore becomes important. So because of these reasons, these are our shortlists from fundamental rights. Now, directive principles. When we look at directive principles, let's understand why and how is this important. See, I have mentioned property rights here, which is a culmination of the relationship between directive principles and state policy because of something called 39B and C. It's conflict with Articles 14 and 19, previously also 31 included, and therefore the larger issue with right to property. Anyway, we'll link it to directive principles. In 2015, there was a question which said, discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided for in directive principles of state policy. Now, this question was asked in 2015, celebrating exactly 30 years to the Shah Banu case. So there's an anniversary question. And if it's an anniversary question, the question will always be very reflective in nature. And again, if you see, they've not asked you your opinion on Uniform Civil Code, because your opinion on Uniform Civil Code might give away your religious affiliations. What they've asked you is, what is stopping us from implementing Uniform Civil Code as it is categorically mentioned under Article 44 of Directive Principles? So your answer, while the issue being extremely controversial, being sensitive, is still an academic and a very neutral answer. And that is something we have to keep in mind under all circumstances. Now, in 2024, we've seen Uttarakhand with Uniform Civil Code. We've seen several other states contemplating certain drafts. We've seen committees that have been formed to examine all of this. So therefore, this is an issue. Not just this, we've also seen very recently people of the same gender have been denied the right to marry. And the Supreme Court, in a remarkably important judgment this year, has used its extraordinary powers and has granted divorce to a couple because of certain extenuating circumstances. So we shall keep that in mind, and all of this eventually comes down to Uniform Civil Code, because marriage is a very important personal law governed across our personal laws. In 2023, the question was rather unique. Who are entitled to receive legal aid, free legal aid? Assess the role of the National Legal Services Authority in rendering free legal aid in India. And there's a context to this. This is a factual question as it sounds to be. Exactly who is entitled to receive free legal aid? And the agency responsible for this, the National Legal Services Authority, NALSA, what exactly have they done? And we're anyways around the 10-year mark in 2024 for the NALSA judgment, which effectively gave transgenders the official status as the third gender. But in 2023, the question was for a very different reason. The question was because in April 2023, if I'm correct with the month, India organized its first ever National Lok Adalat. And it is 35 years to the Legal Services Authorities Act, which is the parent statute allowing for the National Legal Services Authority to even exist in the first place as a statutory organization. And at this first ever National Lok Adalat held in Delhi, I believe close to about 70, 80 lakh odd cases were disposed of in the duration of the first National Lok Adalat. So, specific actionable elements therefore become extremely important. Now, what else in directive principles is an actionable element? You would say equal pay for equal work, but not much has been done on that front. Right to education, yes. But right to education from an education point of view is more of a social justice question, where you would be asked a review of the school education or the other education sectors. Given the fact that higher education has been in the news, particularly in 2024, for foreign university campuses to have been opened up, to the National Testing Agency being in the news for the wrong reasons, therefore a larger issue of regulation of higher education, and so on and so forth. So therefore what eventually ends up happening is, we are effectively dealing with, in directive principles, a larger question which is in contemporary Supreme Court context. So if I look at my factors, I'm looking at anniversaries of judgments, anniversaries of amendments, anniversaries of landmark policy decisions, and important Supreme Court cases in progress. And my outcome is the relationship between fundamental rights and directive principles, ultimately leading to the doctrine of harmonious construction. Minerva Mills is the case, which is 1980, or approximately on the 25-year mark. Property has been one of the primary reasons behind Minerva Mills, because it was effectively about establishing a sense of a balance. In fact, it is in Minerva Mills where it was categorically established that the balance between rights and directive principles is itself an element of basic structure. In fact, it is in Minerva Mills which effectively laid down that limitations on Article 368 are also an element of basic structure, which we will cover in this lecture today anyway. So Minerva Mills becomes important. Property rights, because they're currently being discussed by the Supreme Court. The Supreme Court is basically hearing a matter, and the arguments have been done pertaining to whether the government can acquire private property under Article 39B and C and then redistribute it. The context behind this is that because of Minerva Mills, two directive principles are superior to two fundamental rights if there is no other objection. The two directive principles are 39B and C. The two fundamental rights are 14 and 19. Now 39B and C pertain to distribution of resources and prevention of concentration of wealth. And land happens to be one of the most vital resources. So if the government can acquire land, can it acquire private land? Now there has been a minority view in a state of Karnataka Supreme Court judgment where Justice Krishna Iyer had said that you can. But in a lot of other Supreme Court cases such as Coking Coal and Mafatlal, the Supreme Court has held the opposite, which is why clarity has been sought. And the case is in the news, it is because it has been pulled up by the Supreme Court, and this case is basically the Maharashtra House Owners Association who's filed this case. That's largely because of certain changes that were made by the Maharashtra government to their laws, which allowed for the government to take over old dilapidated buildings, which would basically deprive people of their right to property. That's the context to this. So right to property, relationship between basic structure, fundamental rights, DPSP, Minerva Mills, all of this is in the same universe and therefore is important for Mains 2024 and has to be done in a certain length and breadth of things. When we do right to property, it has to be a very basic question. What is the status of right to property? How did it evolve? And what is the Supreme Court doing about it? That is more than enough. But for Minerva Mills, for the relationship between directive principles and fundamental rights, there is a deeper discussion in place, which we will get into. Now, the grand of it all, basic structure. If it was not asked in 2023 when they had officially finished 50 years, you have to ask basic structure in 2024. If you look at the question carefully, the questions will sound complex, but they're actually not. In 2023, the question was, The Supreme Court of India keeps a check on the arbitrary power of the parliament in amending the constitution. Discuss critically. This is asked because of 40 years to the Kesananda Bharti case, which is 1973. So 2013 becomes your anniversary year. And they ask you a larger reflective question. How does the Supreme Court keep a check on the amending powers of the Constitution? By limiting the amending powers. How does the Supreme Court limit the amending powers? By coming up with something called the doctrine of basic structure. Is this effectively good or not? So, this question basically had two parts. How does the Supreme Court do it? And what are the pros and cons of it? That's pretty much it. The thing with basic structure is, you have to study basic structure in a lot of depth and a lot of detail as far as rights is concerned. And when we do separation of powers or judiciary, when you do judiciary, judicial review and activism, which get completely more strengthened and fortified because of the doctrine of basic structure, have to also be done in a certain amount of detail. That's why it becomes all the more important in that context. Now, 2016. What was held in the Coelho case? In this context, can you say that judicial review is of key importance amongst the basic features of the Constitution? Now, I understand that the IR Coelho case happens to be 2007. This is 2016. The judgment was effectively reported in the month of January, 11th January 2007, if I remember. So the whole 10-year mark is very close to the 10-year mark, which is why it's allowed. So what was held in the IR Coelho case, which is basically that changes to the 9th schedule pre-1973 would also be judicially reviewable if they are questionable on grounds of basic structure. And therefore, you link the basic structure doctrine to judicial review, which in itself is a separation of powers issue. It's a judicial issue. In 2019, again, so if you look at 2016's question, it's again about the impact of the basic structure doctrine. The point I'm trying to make here is, as much as we'll study the evolution of the basic structure doctrine to understand it, more than the evolution, what is more important is the impact of it, the situational justification of it, the necessity of it, and so on and so forth. In 2019, if you look at it, the question is just one step ahead of the 2013 question. The question says, the Parliament's power to amend the Constitution is a limited power, and it cannot be enlarged into an absolute power. In light of this statement, explain whether the Parliament under Article 368 can destroy the basic structure of the Constitution by expanding its amending power. Basically, the question is, the Parliament's power is limited to amend the Constitution, which is very similar to 2013. And it cannot be an absolute power is an extension of the 2013 question. It cannot be an absolute power because it will go against the spirit of constitutionalism. It will go against the spirit of rule of law. It will go against the spirit of what is truly called a majoritarian democracy and not just a representative majoritarian democracy. But the trick to the question was the second half of it. Can the Parliament itself destroy basic structure? And I've attempted to answer that question in this lecture as well. The reason this was asked in 2019 is because when petitions were heard with respect to abrogation of Article 370 and challenges to the CA of 2019, the primary grounds that were actually alleged was that CA goes against the spirit of secularism and secularism is basic structure. Abrogating 370 takes away the nature of asymmetric federalism, which is an extension of federalism, and federalism is basic structure. Of course, with Article 370, the Supreme Court has delivered the verdict. With CA 2019, the case is called the Indian Union Muslim League versus Union of India. The case still is sub judice. When we look at the syllabus fundamentally, this is what we understand. See, the mains syllabus categorically mentions the structure, the functioning, and perhaps the organization of the executive. But if you see the way it is written in the mains exam, this particular line of the syllabus also corresponds to ministries and also corresponds to the judiciary. So that means there is a tinge of a slight reflection towards the union executive. Now, that does not mean that the state executive is entirely out of the syllabus, because if you correspond it to the legislatures, you will see in the last 5 years there are direct questions asked on certain issues faced by the legislatures. For example, analyzing the state legislative councils, which was asked in the last 5 years. So this is my primary syllabus, which means I have to prepare the union executive in great depth. I should also prepare the state executive just as the touch point. There is also going to be a direct interlinkage with separation of powers because of certain executive powers. For example, powers pertaining to ordinances. And I will discuss separation of powers and its larger branches before we begin the first topic, and then we link it back to separation of powers when we discuss this. Thereafter, you will also see comparative constitutions merged in this particular topic. So largely there are three attributes to it, but we're going to be focusing on what is relevant when we cross-reference it to the previous year questions. So let's begin. Now see, when we look at the last 10 years from 2013 to 2023, there is no question in the year 2013. However, in the year 2014, there are two questions from the executive. One which is a question so specific to 2014 that unless something specific triggers, there should not be a question of a similar sort. In 2014, the question was, instances of a precedent's delay in commuting death sentences has come under public debate as a denial of justice. Should there be a time limit specified for the President to accept and reject such petitions? Analyze. So this question was asked in 2014 largely because the Supreme Court, through a 3-judge bench, if I remember correctly, had commuted death penalties of 15 convicts who were awarded those, and their mercy petitions were lying with the President for their final decision. And the President had not conveyed his decision on those mercy petitions, whether the President would have accepted and pardoned them from death penalty or reduced it from death penalty to a lighter punishment. There was no decision made by the President. And therefore the larger question came up that the uncertainty of knowing what is the outcome of my mercy petition itself violates a certain fundamental right, so to speak, under Article 21. So what the Supreme Court did was, it took the 15 convicts who had approached the Supreme Court. Their mercy petitions were pending before the President. And because there was a delay in answering those mercy petitions, the Supreme Court converted those death penalties to life sentences. If memory serves me right, 4 of these convicts were aides of the very dangerous Virappan, who was shot dead in a rather dramatic encounter by the police of the concerned state. So this became a very important judgment, specifically as a trigger point 4 months before the mains exam. So was asked. So unless there is a specific trigger point like this, where the President and the role of the President is not specifically being discussed, There is no reason to do this in detail again. Now the second question also has as a floating current affair significance. The second question that was asked in 2014 read, the size of the cabinet should be as big as the government work justifies and as big as the Prime Minister can manage as a team. Now, how far the efficacy of the government then is inversely related to the size of the cabinet. Now, 2014 is a very important electoral year. It's a very important electoral year because prior to 2014, we were in a hardened coalition, in a very tight coalition. And UPA 2 had almost filled their full quota. After the 91st constitutional amendment, the maximum number of union ministers that you can have is 81. And including the Prime Minister, they had about 79. From UPA 2, when you move to NDA 1, which is 2014 to 2019, because it was a majority government and the BJP singularly was able to cross the 273 threshold, there was a dramatic decrease in the number of Council of Ministers. And from 79 ministers in UPA 2, the NDA 1 had about 46. Now 2024, this year is also an electoral year. If you compare the strength of ministers, it was 46 in NDA 1, it was about 58 or something in NDA 2, and now we're again beyond 70 in technically what is called NDA 3. So coalition governments have a positive correlation with the strength of the union of ministers. The reason why coalition governments have a positive relationship with the strength of the union of ministers is largely because you would want to accommodate the political partnerships that have been fostered to bring the coalition into effect. But besides the point that you have to accommodate political partnerships, what is even more a crucial decision is what is an appropriate size of ministers. On what basis should you decide this is the exact number of ministers we should have? It should have multiple factors in place: inclusivity, specialization needs, generalization parameters, efficiency parameters, and so on and so forth. So in 2024, the exact same question may not be repeated, but the positioning of the Council of Ministers and the larger principle of the doctrine of collective responsibility therefore becomes significantly important. And I would therefore mark it as an important topic for 2024 mains, which is the third topic that I will discuss in the flow of things. In 2015, there is a question directly on ordinances. Resorting to ordinances has always raised concerns on the violation of separation of powers. The question itself acknowledges that the issue of ordinances is actually an issue of separation of powers, though it is the legislative powers of the President and the Governor respectively under Articles 123 and 213 respectively. The question further goes on to state, while noting the rationales behind justifying the power to promulgate ordinances, analyze whether the decisions of the Supreme Court on this issue has further facilitated resorting to this power, and should the power to promulgate ordinances be repealed in the first place. Now, if you notice, the question is largely thematic. The question has three parts. the relationship of the ordinances with separation of powers. Second, the promulgation instances of the ordinances. And third, how Supreme Court judgments, instead of containing promulgation, have facilitated its promulgation to a certain extent. So therefore, it leads to a larger, closer question that should you even have ordinances in the first place? Now, the reason it was asked in 2015 is remarkable. As we just discussed a few minutes ago, 2015 is the time where we are now entering into a majoritarian government phase. We are back to becoming a majoritarian government. So technically, the instances of an ordinance in a majoritarian government should technically be lesser because it's technically a more stable government. But despite that, there were several ordinances that were issued in the year 2015. The most questionable of it was the land ordinance, which basically allowed the government to access and acquire land for developmental purposes in a far easier manner. In addition to that, there were ordinances relating to FDI and insurance, the auction of coal blocks, e-rickshaw regulations, mines and minerals, and amendments to the Citizenship Act, which basically merged OCI and PIO, Overseas Citizens of India and Persons of Indian Origin. Now, a lot of these ordinances were not necessary because the primary condition of an ordinance is that there is an urgent, unforeseen situation which cannot be solved by ordinary law, and there is a satisfaction of the president or the governor that the legislatures must be bypassed to give effect to this ordinance with immediate effect, to bring this into law with immediate effect. In fact, the land ordinance was questioned in the Supreme Court in 2015, and a total of 9 ordinances, which is far more than the national average of about 7.7, was achieved in 2015. So therefore, ordinances became a key concern. Now, ordinances is something which is a standard theory topic and also gets triggered because of certain current affairs. Now, in 2023, to nullify the Supreme Court judgment on Delhi Lieutenant Governor versus Delhi government, where the Supreme Court said that the civil services of Delhi, except those officers who are working in land, law and order and police, will also work under the overall supervision of the Chief Minister. And to counter that, an ordinance was immediately promulgated, creating some National Civil Services Authority for Delhi, wherein the Lieutenant Governor would have certain supervisory powers and the Chief Secretary would also be a member of it. So that becomes a trigger point in 2015. In 2023. Therefore, for the lack of anything else, ordinance becomes a very important issue in 2024. So we mark it accordingly. And there has been another instance where ordinances have been asked. In 2018, the question was, under what circumstances can financial emergency be proclaimed by the President of India? What consequences follow when such a declaration remains in force? Now, this I call a split question. While it is the power of the President to issue an emergency, I still believe emergency is a larger issue of center-state relations. So I will keep emergency as a flag topic for center-state relations. And emergency is extremely important for 2024 because S.R. Bommai was a 1994 case and therefore S.R. Bommai is 30 years old in 2024. But in 2018, why would the UPSC ask you something so specific as financial emergency. Now, the reason UPSC asked this was because of immediate reasons and floating reasons. The immediate reasons were that two states, Tamil Nadu and Uttarakhand, were reporting acute financial health, where respectively the high courts had given directions to the state to fulfill basic minimum conditions. In Tamil Nadu, because of acute financial conditions, the salaries of the transport staff of the government were not being paid. And in Uttarakhand, because of acute financial conditions, the basic funds that had to be released to Uttarakhand schools were not being done. And there were reports of Uttarakhand schools spending their expenditure on non-essential items. 2018 also recorded a standoff between the RBI and the government on certain basic principles of monetary policy, which eventually led to the resignation of the RBI governor at that time, Mr. Urjit Patel. And 2018 also recorded a very high degree of non-performing assets when certain laws pertaining to these, such as the Safarezi Act, were in the news. On top of it, because the GST was being implemented in full swing, there were a lot of additional costs and assimilation that were also being incurred by the people of the country. And the Insolvency Bankruptcy Code had also been put into effect, which also showcased the financial health of several major entities in the country. Though a very difficult question to predict in 2018, and I must say this categorically, even we missed it in 2018, but there was reason to have this question asked in 2018. Now, in 2019, very uniquely, because when we talk about the executive, technically the Union Executive is the President, the Prime Minister, the Council of Ministers, the CAG, the Attorney General, and the Civil Services. Collectively, these you would call collectively as the Union Executive. But in 2019, the question was specifically an Attorney General, and there was a reason behind it. The question was, the Attorney General is the chief legal advisor and lawyer of the Government of India. Discuss. Now, there were two reasons why this question was asked. First, there were certain comments that were made by the Attorney General with respect to the Sabrimala issue, which were found to be unbecoming of the office of the Attorney General. And two, the Attorney General was representing the government in the Rafale case, which was being heard by the court in 2019. And the Rafale case pertained to the actions of a previous government. So there are two basic questions that are actually very pertinent when it comes to the Attorney General. First, who is the Attorney General representing? And second, are you responsible to also represent past actions of the government with equal rigor? If you read the constitutional provisions carefully, it does not say Attorney General of India. The Constituent Assembly was remarkably specific when they said Attorney General for India. So who's for India? Is it ultimately the government, or is it far more ultimately the citizens? It is understood that the Attorney General is to represent the ultimate sovereign, which is the Indian citizens, through the government. But more importantly, if the Attorney General has been appointed by the current government and there are some misdeeds of the previous government which the court is hearing, how does the Attorney General position herself before the highest court of this country? So therefore, conflict of interest, representation mandate, and an appointment removal bias becomes the three primary issues when it comes to the office of the Attorney General. In 23 and 24, there is no specific reason for the Attorney General to have been in the news. In 2020 and 2021, again, there are no questions. As you saw that there were no questions in 2016 and 17. So the UPSC tends to skip 2 years after asking a question consecutively for maybe a year or two. But in 2022, there seems to be a plethora of questions. The first question was, and again, technically the Vice President is also supposed to be the executive when the Vice President is performing the functions of the President, but the Vice President for a majority of her tenure is basically the chairperson of the Rajya Sabha. That is your key identification for the purpose of the Vice President. So I would still call this a split question between the executive and the legislature. But because it is the office of the President, office of the Vice President, I'm also dealing with it here itself. In 2022, the question was, discuss the role of the Vice President of India as obviously the chairperson of the Rajya Sabha. Now, the reason this was obviously asked in 2022 is because we had a new Vice President in 2022. Now, this again is a split question, as I said before, between the executive and the legislature. And therefore, we will deal with this in theme number 5, which is legislatures. Or we'll deal with it in the next lecture, which is legislatures. Now, when we answer the question of presiding officers, and presiding officers are very important for 2024, largely because the previous Lok Sabha was the only Lok Sabha which did not have a deputy speaker. So the larger role of presiding officers again becomes very important for 2024. So in lecture number 4, when we discuss legislatures, we'll have to get into some detail around it. Then we move to the next year in 2022. Again, there is a question. And this is a question on ordinances. Discuss the essential conditions for the exercise of legislative power by the governor, and discuss the repromulgation of ordinances by the governor without placing them before the legislature. Now, when we study ordinances in greater depth, you'll understand that between central and state ordinances, there is a greater tendency of state ordinances to be repromulgated. Around the 700 odd central ordinances, barely 40-45 have been repromulgated. But if you look at states like Kerala, they've repromulgated more than 100 out of 150 ordinances within the same year. Now, for that very specific purpose, there was a Supreme Court judgment in 2017 called Krishna Kumar Singh. So 5 years approximately to that judgment. But why would this question be asked in 2022? Because in 2022, there was a detailed academic study which was greatly talked about in the newspapers. So the editorials picked it up, where a legislative think tank called the PRS had done an extensive survey on the intensity, the frequency and the intent. The intensity, the frequency and the intent of ordinances. So ordinances therefore were asked. Because ordinances, as I said before, was in the news recently because of the Delhi ordinance which was uncalled for, we'll have to prepare ordinances in detail. And in 2022, there was another question. Critically examine the procedures through which the presidents of India and France are elected. So putting a hint of comparative constitutionalism. Because in 2022, both India and France had new presidents. This means almost every question that is asked in the executive is asked for a specific reason. There is either an immediate trigger or there is a floating series of events which raise questions towards a larger picture. So if I look at the factors are the following. You have certain transient issues which have been there for a longer time. Several issues, though smaller in nature, give rise to a larger issue. For example, the question on the Attorney General and financial emergency. Electoral cycles are duly noted for if there is a massive change in the format of government. Now, this year, there is a change again from majority government to a coalition government. So, in that context, the role of the ministers and the responsibility of the ministers could be a question, though unlikely. Ordinances is an extraordinarily thematic question to be asked, and because again of the Delhi ordinance issue, ordinance becomes important. There are no new appointments to the executive per se in 2023, so not particularly important. There are also no important anniversaries of judgments or constitutional amendments that we have to particularly take note of. So, with all of these factors in mind, I think there are only 3 issues that become important, out of which 2 are very important, and 3 is sort of to be done just to keep ourselves safe. The first issue is that of ordinances. The second issue is about the duality of the governor. Now, I understand that the governor has not been asked, and I understand that there has not been a single question on governor. But if the UPSC can ask you state legislatures, they can ask you the position of the governor in the context of the federal setup. Because in 2023, governors of Kerala and Tamil Nadu were massively in the news because they sat on a large chunk of bills without deciding to assent or not give their assent. And the matter went up to the Supreme Court as the respective state governments petitioned the Supreme Court to ask the governor to take necessary action. And when the governor mostly forwarded their bills respectively to the president, it became a larger issue of the integrity of parliamentary democracy at the level of the states. We'll discuss this in detail. So the governor is a very uniquely placed office and therefore must be analyzed accordingly. If we look at the syllabus for parliament and state legislatures is explicitly defined in GS paper 2. In fact, both the words parliament and state legislatures are categorically written in our GS paper 2 syllabus. And not only this, certain dimensions are also mentioned. For example, the syllabus explicitly mentions structure, it explicitly mentions functions, it explicitly mentions conduct of business, it also mentions powers and privileges. And then it says issues arising out of these. The structure, functions, conduct of business, powers and privileges, and issues arising out of this. There would be a little bit of a cross merger of international comparative constitutional schemes, which is perfectly all right. And this is generally how the length and breadth of theme number 4, union and state legislatures, is sort of decided. Now we'll get more clarity in terms of what really needs to be done. We'll understand the reasons behind it, the frequency of questions being asked, and so on and so forth when we understand previous year questions. So let's look at this. So in 2013, the very first previous year question, the role of an individual MP, the member of parliament, has diminished over the years. And as a result, healthy, constructive debates on policy issues are not usually witnessed. How far can this be attributed to anti-defection law, which was legislated but with a different intention? Now, very interestingly, though the syllabus says structure, functions, conduct of business, and powers and privileges, If you look at the syllabus carefully, the structure is of the parliament, the functions are of the parliament and the parliamentarians, the conduct of businesses of the parliament, and the powers and privileges are of the parliament and the parliamentarians. The point I'm trying to sort of bring in here is, when we're referring to the larger theme of legislatures, we're referring to the legislatures as an institution and legislators as ingredients of that institution. So therefore, when we look at the syllabus in a certain capacity, we look at this syllabus in a two-dimensional format. We look at it from the point of view of the legislatures, and we also look at it in point of view of the legislators. So structure, functions, conduct of business, and powers and privileges of the legislatures and of the legislators. And therefore you can have a set number of issues that can therefore be identified, which we will do in some time. So that's the idea. So this question in 2013 is about the role of individual MPs and how anti-defection law has led to a decline in the role of individual MPs. So carefully, the question is actually about anti-defection law, but the question is in the context of the role of individual MPs. So what generally happens is, students tend to not write about the role of individual parliamentarians and completely write everything that they know about anti-defection law. That is not an appropriate way to do this. In 2013, the reason why this question was asked is because it was a pre-election year, and therefore there were several issues that had come to the forefront which required some very honest deliberations on the floor of the House. One of the issues that had come out in 2013 was foreign direct investment in multi-brand retail. Now, at that time, Walmart was in talks with Bharti Mittal to come up with a joint venture of some sort to introduce large-scale multinational-style grocery departmental stores in India. Now, this was generally questionable because the interests of the local Kirana shop owner was in jeopardy. As an outcome of this led to a major uproar. And an uproar was equally echoed on the floors of the parliament. Now, very interestingly, when it came down to a vote on the floor of the parliament, the political party in favor of FDI and multi-brand retail, all members of that political party had a similar yes vote. And all members of the political party who were against FDI and multi-brand retail had a unanimous no vote. It is rather impossible to have so many human beings have exactly the same opinion just because they come from a political party. And as a parliamentarian, your individual role is to also critically evaluate propositions on the floor of the parliamentarian. And anti-defection law, because a whip can be issued and you cannot go against the wishes and the directives of the party, therefore make the role of the parliamentarian slightly more complicated. This was the trigger event. On top of that, with regards to anti-defection law, the Supreme Court had made a very important reservation. Had made a very important reservation in the sense that even a non-member can technically complain against a member for anti-defection or for defectory practices. At the same time, the constitutional validity of anti-defection law was being challenged because it undermined parliamentary democracy, which was basic structure. The Supreme Court upheld anti-defection law per se. And again, similar parliamentary behaviors based on political loyalties had a very sort of a pre-decided sort of a discussion when it came to several scams that were unearthed, such as the Colgate and the 2G scam in 2013. Now, in 2014, if you notice carefully, the question was on powers, privileges, and immunities. The powers, privileges, and immunities of the parliament, we collectively, for simple reasons, just call it privileges. The privileges of the parliament and its members, as envisaged under Article 105, leave room for a large number of uncodified and unenumerated privileges to continue. Now, uncodified and unenumerated are two very different things. Uncodified means there are 10 different places where privileges are mentioned. They're not mentioned in the same singular document. This means the same thing as the difference between a written and an unwritten constitution. Unenumerated means it's not written anywhere in any of those 10 places, but is still practiced as a method of convention. And in fact, our parliamentary privileges are largely driven by British parliamentary conventions. As a consequence of this, there are two basic issues. One, they're unenumerated, and two, they're uncodified. So the question was, assess the reasons as to why they're not written in one single place, the absence of legal codification, and two, how can you solve this problem? Now, how can you solve this problem has two aspects. One, should you codify privileges in one place? And two, even if you can't codify in one place, how can you make the existing system transparent, fair, and more accountable? That's the idea. Now, the reason this was asked in 2014 is because of the Sita Soren case. Now, the Sita Soren case was on appeal to the Supreme Court in 2014. It was filed in the Supreme Court as an appeal from the High Court in 2014 from the Jharkhand High Court. Now, in 2024, the Supreme Court finally has given a verdict on this. And therefore, in 2024, this becomes one of the most important areas to cover as far as the exam is concerned. Because in 2024, the Supreme Court in the Sita Soren case has said that your parliamentary privileges do not cover acts of corruption. Everything else we can still look the other way. But corruption is not justified just because you have parliamentary privilege. We'll cover this in detail in this lecture itself. Then in 2017, we see a question on parliamentary committees. Now just keep this in mind. You will generally have a question on overall utility of parliamentary committees, specific focus on financial committees, and departmentally related standing committees. These are generally the dimensions that the UPSC has covered in the last 10 years or so. In 2017, the UPSC asked, discuss the role of Public Accounts Committee in establishing accountability of the government to the people. Now, this was particularly asked in 2017 because this very Public Accounts Committee had summoned the Prime Minister and the Governor of the RBI because of demonetization as a policy which was executed in 2016. Consequently, the RBI had also issued a report which said that more than 98% of the cash of the notes that were declared as illegal money were returned to the banking system in some form or manner. So the demonetization policy was therefore even more voraciously questioned. But the 2017 question is about role of the Public Accounts Committee in accountability and general transparency in the system. And the Public Accounts Committee is a financial committee. Now in 2017, you will see the first and perhaps the only question which is on procedure. So the second question that is asked in 2017 is a question on procedure. The Indian Constitution has provided for holding joint sessions of two houses of the Parliament. Enumerate the occasions when this would normally happen, and also the occasions when it cannot with reasons thereof. Now, the reason this was asked in 2017 was fairly simple. It was asked in 2017 for the simple purposes of this. It was asked because in June 2017, if I remember correctly, a special joint session of both the houses was addressed, was invited, was called for to introduce the GST Constitutional Amendment Bill. It was not passed, it was not debated, was voted. It was simply introduced so that you could tell the story of why you need to replace the indirect taxation system with a singular taxation principle called the goods and services tax, so that you can have a more efficient and a more accountable and a more transparent taxation system in the indirect format. There are a few trigger events that happen in the country which can be asked in so many different ways in the same mains exam. How GST in 2017 was asked like this. It was also in 2017 when there was a direct question on GST, which I will discuss in Federalism eventually. At the same time, if you remember, when the national education policy was announced, almost every paper in GS 1, 2, 3, 4 had a question on national education policy. Paper 2 would have a national education policy, education structure question. Paper 3 would have national education policy and technology. And paper 4 would have national education policy and ethical values. But the questions were there. So every once in a while, there is that watershed moment where that issue becomes so important that it is asked in multiple forms and shapes and sizes in different parts of the UPSC mains exam. GST is one of those. So that's something we must remember. So 2017 is this. Then in 2018 again, what do you think? Why do you think committees are useful for parliamentary work? So, a general question on committees. Discuss in this context the role of estimates committee, which is a financial committee. This was asked in 2018 because the estimates committee, which only comprises of members of the Lok Sabha, because it is performing a financial policy recommendation function and therefore the Rajya Sabha has to be kept out of it. The estimates committee in fact had recommended changes to the way we calculate GDP. It was argued that the GDP in its current calculation status does not reflect the true economic realities and is not a true indicator of economic growth, development and other soft issues that exist in the country. And as a consequence of this, the chief economic advisor was also invited to appear before the estimates committee, not only for GDP issues, but also because of a meteoric rise in our non-performing assets. And this therefore had led to a larger question on estimates committee to be asked in the mains exam in 2018. Another question in 2018 that was asked was a comparative question between India and the US. Now, India and the US are two large democracies. Examine the basic tenets on which both these political systems are based. Now, very interestingly, neither India nor US in 2018, and understand this, neither India nor US in 2018 have had any presidential election or have had any other form of major elections in both the countries. But why have you asked a question in 2018? It's because this is the first time, and that's why I purposely kept this blank. This is the first time a question on international comparative constitutional schemes was asked in 2018. This was to set the ball rolling. If it is for the first time you're asking a question comparing constitutional schemes of other countries, the most obvious first question you would ask is the difference between presidential and parliamentary democracies. Later on, the questions have evolved to France's comparison on secularism, US's comparison on equality, UK's comparison on judiciary and parliamentary sovereignty, and so on and so forth. But the first ever question comparing constitutional schemes of India with that of other countries had to begin with a comparison on parliamentary democracies. Other than that, there is no other contextual reason why this could be asked. 2019 will remind you of the question of 2013. 2019, the question was, individual parliamentarians' role as the national lawmaker is on a decline. Sounds very similar. Which in turn has adversely impacted the quality of debates and their outcome. Discuss. This is basically the 2013 question minus a direct reference to anti-defection law. Now, why this question was asked in 2019 is also fairly unique. Because 2019 is a election year And if you look at the general performance of the 16th Lok Sabha, despite being a majoritarian democracy, fewer bills were being referred to parliamentary committees. Fewer bills were being discussed on the floor of the House. There was a high degree of ordinances that were being promulgated in this tenure. So, if you are a majoritarian democracy, which should instill a degree of confidence in you, why are you still not allowing for great open-ended and free-flowing parliamentary debates to happen on the floor of the House? And as a consequence of this, 2019 was why the question was asked. In 2020, you will see two questions. And both of these questions have a very interesting context. 2020. Once a speaker, always a speaker. This is a very indirect reference to the UK system of things. Do you think this practice should be adopted to impart objectivity to the Speaker's office? What should be the implication for the robust functioning of parliamentary business in India? So this is the question combining structure and functions of the Lok Sabha, which is the House of the Parliament. Now the reason this was asked is because in 2020 the Supreme Court, while delivering a judgment in Kesham Singh versus the Manipur Legislative Assembly, gave a remarkable suggestion. And this was again about the impartiality or the partiality of the presiding officer, and largely to do with anti-defection law. That was the trigger. The Supreme Court in 2019 said that it would be better if either the Election Commission or an independent tribunal or maybe a committee of ex-judges is constituted on a case-by-case basis to examine instances of defection that have to be punished on the floors of the parliament. Because clearly the speaker's partiality or the conflict of interest either has very orchestrated defection decisions against the opposition, or enough time is let to be passed that the decisions would not matter eventually. This is why in 2020 there was a question on the speaker, because the observation was on the speaker. In 2020 again, there was another question on one of the houses, which is the Rajya Sabha. This was based on an editorial 3 months before the mains exam. The question was, and what is very interesting about this question is, this question automatically gives you an opinion embedded in the question. So answering this question requires a degree of fine-tuning. The question is, the Rajya Sabha has been transformed from a useless Stephanie tire to the most useful organ, most useful supporting organ in the past few decades. Highlight the factors as well as the areas in which this transformation could be visible. Now, the reason this question was asked in 2020 is because 2020 marks the 250th session of the Rajya Sabha. And at that time, if I remember, Sri Venkaiah Naidu had written a remarkable editorial in the Hindu explaining the role of the Rajya Sabha. Now, the idea here is, and the question says that the Rajya Sabha is now better than what it was set it out to be. The Rajya Sabha is truly doing the job it was meant to do. Now tell me why the Rajya Sabha has been able to transform its role, has been able to do a better job, has been able to be competent. The question is not about whether you think Rajya Sabha has done a good job or not. The question is that we are telling you Rajya Sabha has done a good job, and therefore, please tell me where and how do you think the Rajya Sabha has done a good job. So there is an inherent opinion embedded in the question in that context. In 2021, again you will see a series of 3 questions. The first question that you see in 2021 is a question which is half legislatures and half separation of powers. To what extent, in your view, the parliament is able to ensure accountability of the executive in India? Now, this question comes in the backdrop of the COVID and therefore farm law ordinances and so on and so forth. where parliamentary committees were to be set up to examine how the government has managed the pandemic. And two, the sheer promulgation of farm laws originally as an ordinance was also fairly questionable from several corners in the country. A, the farm laws were not urgent enough. They were certainly not urgent enough to be passed as ordinances first and then be converted into ordinary parliamentary laws, only to then be repealed. So there was a larger issue at that point. So this question, while yes, is about the role of the parliament in ensuring accountability, it is also about checks and balances, which is a function of separation of powers. So this has to be done in that sense. The second question that was asked in 2021 was the question triggered by a local political development. And this is for the first time that you see questions on state legislatures or officers of state legislatures being asked. And you will see this as a recent occurring of late. Explain the constitutional provisions under which legislative councils are established. Review the working and the current status of legislative councils with suitable illustrations. Now, the reason this was asked in 2021 is because of something that happened in West Bengal. Now, historically, West Bengal used to originally have a state legislative council, but at their request, they abolished it a few years later. 2021 was also the year of elections in West Bengal. And the Chief Minister of West Bengal lost the elections, lost her seat during the elections, to be more precise. So as a result, there was a larger discussion that to be absolutely safe and to avoid these hits and misses, perhaps one could have a state legislative council in West Bengal, so that any political turbulences do not lead to any leadership turbulences. And this is why this was asked in 2021. The third question that was asked in 2021, and if you notice, this is almost mid-electoral year. Do departmentally related standing committees keep the administration on its toes and inspire reverence for parliamentary control? If you notice, parliamentary control and parliamentary control is repeated just after a year's gap. Here, one of the ways that the parliament ensures accountability is through parliamentary committees, and one of the types of parliamentary committees is DRSCs. So the question was on DRSCs. Now, the reason this was asked in 2021 is because DRSCs were tasked with the review of how COVID was being managed. There was also issues of privacy attached to the Arogya Setu app, which was also introduced during the pandemic. And there were also committees to examine whether the farm law bill was truly needed or not. As a result, this was in focus. In 2022, when we flagged this question in executive also, discussed the role of the Vice President of India as the chairperson of the Rajya Sabha. This is because a new Vice President has been elected. And that is why the question was asked. And the Vice President of India is the ex officio chairperson of the Rajya Sabha is a statement which is more than just an ordinary one. This means the primary function of the chairperson of the Vice President of India is to be the chairperson of the Rajya Sabha. And only when the President is temporarily unavailable is when the Vice President officiates as the President, which is a minority of times in India's history. So what is the Vice President actually supposed to do at most of the times is to preside over the sittings of the Rajya Sabha, which is why the question is framed in such a manner. Last year, there were 3 questions that were asked. In 2023, the first question that was asked was, discuss the role of the presiding officers of state legislatures. Now, the answer is almost a mirror image. But just because somebody is written presiding officers of state legislatures, you may want to add 1 or 2 points which are largely reflective of the state of affairs in our state legislatures. But 90% of the points that hold true for presiding officers of central legislatures are also true for presiding officers of state legislatures. So discuss the role of the presiding officers of state legislatures in maintaining order and impartiality, in conducting legislative work and facilitating best democratic practices, which is basically the role of the presiding officer. Now, the reason it was asked is because 3 states, Maharashtra, Tamil Nadu, Karnataka, had seen major political turmoil in the recent past. And each of these had very questionable decisions that had to be taken by the presiding officer of those houses. Even if you didn't know the context, you would have anyways prepared the role of the presiding officer for that particular state, for the country, for the Lok Sabha, for the Rajya Sabha. You had to just replace the role with the role of the state legislatures. The second question that was asked in 2023 was explain the structure of the parliamentary committee system. How far have financial committees helped in the institutionalization of the parliament? Again, a question on parliamentary committees, but this time they've asked you the broad structure of the parliamentary committee system. And how far, again, this time all the financial committees have been asked together, have helped in the institutionalization of the Indian Parliament. To my mind, this is a very, very nuanced phrase. Institutionalization of the Parliament. How do you institutionalize something? By creating a set number of procedures, set number of ways to effectively bring the objectives of the institution to light. Now, the reason this was asked is because the parliamentary committees, more particularly the financial committees, in 2023 had raised severe objections on the quantum of defense spending, 2, the larger issue of GST compensation that had to be awarded to the states was in the news, and 3, the issues of irregularities in the way the Adani group of companies were to be awarded certain contracts were to be examined by these committees. And this is why there was a larger question that was asked. The last question that was asked last year was compare and contrast the British and the Indian approaches to parliamentary sovereignty, which means both of us are parliamentary systems of government, but Britain is parliamentary supremacy and sovereignty, while we are parliamentary sovereignty but not parliamentary supremacy. So how are we similar? How are we different? Why are we similar? Why are we different? Is essentially what the answer to this question is. It is because in 2013, temporarily so, United Kingdom had a new Prime Minister, who now again we have a new Prime Minister in the UK. This person was Rishi Sunak. And there was judicial reform in the UK with respect to the state of the parliament and parliamentary laws being questioned by the judiciary. So with all of this in mind, there are certain repetitions, there are certain spaced repetitions, there are certain trigger questions. And therefore questions have to be prepared in a very, very defined manner. There are some dead theory questions that have to be done just in case. There are some high priority things that have to be done, and so on and so forth. Now, officially, the Mains Syllabus says structure, organization, and functioning of simply judiciary. Now, this itself is not a good enough understanding or a good enough hint as to whether this is all elements of judiciary. Does it refer to higher, lower, and other forms or not? And it's generally understood that this refers to higher judiciary and what we could say in some form your innovative judicial mechanisms such as a Lok Adalat or a Gram Nyayalaya and so on and so forth. But what it specifically does not deal with in terms of what the syllabus offers is in fact what is called lower judiciary. Now, lower judiciary is obviously fairly technical and also is fairly customized given the fact that the states have a slightly important role to play. But that's also not just where the syllabus ends. It's also important to understand that there are also several parts in the syllabus where you can see an intersection with judiciary. Now, what these parts are, let's understand. For example, in point number 3 of your syllabus, you find something that says dispute resolution mechanisms, which basically also translates into alternate dispute resolution. And one could also argue that Lok Adalats, more than Gram Nyayalayas, are actually forms of what is called alternate dispute resolution. And attached to the word alternate dispute resolution, you also find something called separation of powers, where concepts like judicial appointments, concepts like judicial review and activism tend to also have an impact on separation of powers. In fact, things like tribunals also tend to have an impact on separation of powers. And say something like tribunals also sort of fits somewhere midway between judiciary and dispute resolution mechanisms. And if this wasn't enough, you will also see one of the most important givings of higher judiciary in our country, which is basic structure, which is also separately mentioned in the mains syllabus. On top of this, you will also find important or significant constitutional amendments. Some of them will pertain to, of course, the role of the judiciary. And again, the syllabus is not entirely complete because we've had questions comparing the divergence and the convergence of the judicial processes between England and India. So comparative constitution also tends to have some sort of a role when we study judiciary. So in fact, once we put all of this together, we understand that it's not just judiciary that we are studying. We are in fact studying, to a large extent, the judicial system of our country and figuring out what is what. And as a very small aspect of the judicial system, we'll also look at the other stakeholders in the larger legal system of the country. So that's something that we must always remember. Which is why topics like judiciary therefore have to be done with a fair degree of caution, and also therefore have to be done with a fair degree of restraint, because it can be overwhelming in terms of its coverage. Now let's look at what the UPSC has asked in the last 10 years pertaining to judiciary. So it all starts from 2015. In 2014, the UPSC asks a question. Starting from inventing the basic structure doctrine, the judiciary has played us a highly proactive role in ensuring that India develops into a thriving democracy. In light of the statement, evaluate the role played by judicial activism in achieving the ideals of democracy. Now, if you look at this question is a fairly nuanced question because of the sheer number of terms and concepts this question tends to throw at us. This question sort of gives you an evolution of the judiciary, and it also asks you to specifically examine the impact of judicial activism on democracy and the values of democracy. Now, first things first, this question was asked in 2014 is because of 65 years of the Supreme Court, and coincidentally, in 2024, we're looking at 75 years of the Supreme Court, which is a landmark event, and therefore a question very similar to this is highly probable in Mains 2024. So perhaps the role that the courts have played in democracy, perhaps a larger idea of access to justice, which is, of course, not just the domain of the Supreme Court, but the judiciary in general. But because you're looking at 75 years of the Supreme Court, so what specifically is it that the Supreme Court has done for the country? Which is why I think the larger role of the Supreme Court is more important than access to justice. The other reasons why this was asked in 2014 was because of a series of judgments that were obviously in and around the news. Now, first things first, Jallikattu has been in the news recently over the last year or so, but the judgment originally of Jallikattu had come in 2014 as well. This is also the time of the Shreya Singhal Article 19 case. There were also directions that were given by the Supreme Court which were more towards judicial activism and less towards judicial review, where details of foreign bank account holders were sought. Similarly, the Nalsa judgment, which recognizes transgenders as the third community officially, was also recognized. And not only this, the NJAC Act was passed in 2014, later struck down in a year's time by the Supreme Court in 2015. So there was a lot that went around, which is why this was an important year for an overarching question on, say, the role of the Supreme Court or the role of, say, judicial activism, which is largely the domain of the Supreme Court or the higher judiciary, to an extent also by the high courts. Now, in 2015, now this is a question from dispute resolution mechanisms. What are the major changes brought in by the Arbitration and Conciliation Act 1966 through the recent ordinance promulgated by the President? How far do you think it will improve India's dispute resolution mechanism? Now, obviously why this has been asked is in the question itself, but given the fact that just about a week or so ago, the Supreme Court was holding an there was a national ADR conference. The Supreme Court, to commemorate 75 years, is also holding a special Lok Adalat. Also to the fact that we've recently passed a mediation law. So alternate dispute resolution to that effect also becomes important for Mains 2024. And that's something that we'll have to keep in mind as alternate dispute resolution mechanisms. Now, in 2017, 16 I think is the only year where they've not asked a question on judiciary per se. But in 2017, they've asked, critically examine the Supreme Court's judgment on the National Judicial Appointments Commission. And mind you, the judgment had come in 2015 with reference to the appointment of judges of higher judiciary in India. Now, there were two reasons why this was asked. Is because after the judgment came out, the Supreme Court had in fact sort of self-declared that they will come up with certain reforms to collegium processes, and they will try to bring in some form of internal reforms and internal transparency to the collegium process as a whole. Not only this, there was also something far more interesting, is that in 2017, the Supreme Court was functioning with a bare minimum 25 judges, and there were certain changes that were made to the memorandum of procedures. I will discuss this in the larger structure of judicial appointments, which were fairly questionable. Now, this also becomes important in 2024 because it's 10 years to the NJAC, but we will understand the conflict because it's in 2023 where judicial independence has been asked, which also means that judicial appointments is a very integral part of judicial appointments, independence, and we'll come to that later, but nonetheless important. In 2018, how far do you agree with the view that tribunals which is, though technically not mentioned anywhere in the main syllabus, is technically an amalgamation of dispute resolution mechanisms and structure, organization, and functioning of the judiciary, curtail the jurisdiction of ordinary courts. So this therefore also becomes an issue of separation of powers. And in view of the above, discuss the constitutional validity and the competency of the of tribunals in India. Now, the reason this is asked in 2018 is because through the Finance Act of 2017, certain very questionable changes were made to the tribunals ecosystem, and also several tribunals were either amalgamated or abolished. As a result of this, there were, of course, greater discussions on what is the use of tribunals and the larger issue of tribunalization of justice. And there was also a Law Commission report which had adversely advised against over tribunals in a certain manner and spirit, which is why in 2018 there was a question on this in that context. This, of course, was a major highlight. After the 2017 Finance Act, there were also Supreme Court judgments. Eventually, the Roger Matthews case and the South Indian Bank case, which have also been on the tussle between who's actually going to control tribunals and so on and so forth. So that, of course, is going to be a problem. Now, in 2019, there was again another question on tribunals. The question was very specific because of a very, very specific context. Now, the question was, the Central Administrative Tribunal, which was established for redressal of grievances and complaints by or against central government employees, nowadays is exercising its powers as an independent judicial authority. Again, the conflict and the autonomy of tribunals. And there is some current affairs context, if you see nowadays, which is mentioned in the question. Now, the reason why this was asked was because the CAT, while discussing service matters, had ruled on RBI pensions, which could have largely been interpretation of law or a larger policy issue, which to the minds of many was not exactly the domain of the Central Administrative Tribunal, and there was some form of a co-relationship between the Delhi High Court and, of course, the Central Administrative Tribunal, which was in Delhi, where the Delhi High Court had sort of pulled up the cat for not deciding cases on time. And this is something we also generally see, where we generally seek directions from the Delhi High Court to give a time-bound resolution to, say, certain urgent cases which come up before the cat. So this has largely been how things have been. But 2019 onwards, you barely see questions on tribunals or dispute resolution mechanisms per se. Now, in 2020, now this is where in some time COVID and everything else is also going to kick in by the end of the year. But 2020, the judicial systems in India and UK seem to be converging and diverging in recent times. Highlight the key points of convergence and divergence between the two nations in terms of their judicial practices. Now, the reason this question was asked in 2020 is because in a matter of great surprise. So first things first, it's 10 years to the UK Supreme Court was established in 2010, though not very important. But what had happened in 2020 was that the UK Supreme Court had overturned the prorogation of the Parliament, which was an order issued by, at that time, Her Majesty, and it became a larger issue as to how dare the court get into parliamentary proceedings, and therefore it became a larger issue, and therefore a comparative question came between India and UK's judiciary. In 2024, I don't think there is any reason whatsoever for a comparative question to be asked between comparing India and UK's judiciary. Now, there was a second question in 2022, very strangely, and you'll now see that sometimes two questions are asked from judiciary in the last 5 years. In 2020, you'll see a question, which is actually a very interesting question if you understand the crux of it. Judicial legislation is antithetical to the doctrine of separation of powers as envisaged in the Indian Constitution, therefore going back to our original understanding of the syllabus. In this context, justify the filing of a large number of public interest petitions praying for issuing guidelines to executive authorities. Now, of course, one of the things that the Supreme Court generally tends to do with public interest litigations is issue a list of do's and in some cases a list of don'ts to the government, which is largely the executive. And while issuing a list of instructions to the executive, the Supreme Court also tends to sort of get into domains of policy or make decisions for the government. Now, the reason this was asked in 2020 is because India's first ever PIL case, Husainara Khatun, which was about the state of prisoners, if I remember correctly, was commemorating 30 years. So therefore, it becomes important. Now, in 2021, discussed the desirability of greater representation to women in the higher judiciary to ensure diversity, equity, and inclusiveness. Now, the reason this was asked in 2021 is because for the first time, India had the largest number of lady judges in the Supreme Court. And this was unprecedented because we've never had those many lady justices. I think we had 3 to 4 lady judges at that time, which I don't know when it's going to happen again, but was a landmark moment. So in the context of that, and this was all 2-3 months before the mains exam, so there was a larger question on more women, and therefore there was also a parallel question about gendered justice in one of the other papers around that time. Now, in 2023, they skipped 2022. In 2023, there were 2 questions. One, constitutionally guaranteed judicial independence is a prerequisite of democracy. Now, if you take a plus minus 1 NJAC 2014, the timeline sort of fits. But what is a more apt reason as to why there was a question on judicial independence in 2023 was in fact a tussle between the law minister, who had made certain remarks on the way judges were being appointed and had called for maybe there's high time that we now have changes to the collegium system. And the Chief Justice of India on several occasions, including several national conclaves, had therefore given his point of view, saying that the collegium system works just about fine, and people generally have a misconception that it's not objective or it's not meritorious enough. So that could have also perhaps led to a larger question on judicial independence, which, if I remember correctly, for Means Magna Carta 2023 was categorically done because I had a feeling it could come. Same is the case with greater desirability of women. If you, at that time, I think I'd done the Magna Carta on YouTube and had done this question also for 2021. Now for 2023 again, there was a question on who is entitled to receive free legal aid and discussed the role of the National Legal Services Authority in rendering free legal aid in India. Now, a straightforward reason that was why this question was asked is because in April 2023, India's first ever National Lok Adalat had taken place, and therefore the larger idea of legal aid and access to justice were underlying themes, and that's why it was also there in Mains 2023. Now, with all of this in mind, this is why there has to be a very categorical way to look at how questions are generally asked. If you do a quick review of PYQs, and we've now come to a point in our Magna Carta means that we now start articulating structures, articulating introductions, then start layering our answers. That our first layer guarantees us 110, our second layer guarantees us 120, and if we push beyond it, we come to what is called 130. Now, we'll come to that in just about 2 minutes. But if you generally see, there is a finite number of things that have been asked in all of these questions. So you'll see judicial activism and its impact being asked. You will see ADR questions being asked. You will see judicial appointments and NJAC to be asked. You will see a larger question on tribunals that was asked in 2018. In 2019, you'll see a specific question on CAT. Then you'll see a larger question on comparing India and UK's judiciary. In 2020, you'll see a question on PIL and how PIL leads to judicial legislation, which is also an impact of what is called judicial activism. Then you also have a question on gender and judiciary for a specific context. And then you have independence of judiciary and judicial appointments, etc., to be a larger theme in 2023. And then you, of course, have NALSA and Lok Adalat in 2023 yet again. Now, the conflict is that 2024 is 10 years to the NJAC judgment. But in 2023, they've already asked judicial independence. So to be on the safer side, we will still cover judicial independence, but we'll have to do this rather systematically. Now, so therefore, what becomes our shortlist of topics? So to my understanding, in 2024, if you look at the last year and a half of the Supreme Court, while the Supreme Court has delivered some fairly important and some fairly monumental decisions, there has rarely been an issue with the functioning of the Supreme Court per se, or the higher judiciary that has largely been in the news significantly enough. And therefore, while most of these questions pertain to the higher judiciary or tribunals, a dedicated context seems rather unlikely. But we are in the 75th year of the Supreme Court of India. So in the larger theme of the 75th year of the Supreme Court of India, there are going to be certain topics that have to be covered. If we look at the syllabus, explicitly in the syllabus would you find separation of powers very explicitly and categorically mentioned. In addition to this, you will also see that in comparative constitutional schemes, one must be able to also understand how separation of powers is positioned between the US and the UK. On top of this, you would generally see certain applications of separation of powers which convert into certain core issues which therefore can be addressed through the various parts of the syllabus. So what basically happens with separation of powers is this, that separation of powers, when studied for this exam, first has a direct correlationship with checks and balances, because separation of powers is not absolute in any form. And then separation of powers and checks and balances have effectively two dimensions. The first dimension is a thematic dimension. The second dimension, as we understand it to be, is an issue-based dimension. Now let's figure out what exactly this means. When we look at a thematic dimension to separation of powers, we look at it in terms of the branches of government. So what we basically do is a permutation and combination approach. First, we pick up the legislature and we understand how the legislature is separate, and then we understand how the legislature, by interfering in the executive and the judiciary, performs a check and balance function. That's exactly what we do, and that's the primary cause of this lecture. Similarly, pick up the executive, check how the executive is separate, and see how the executive interferes with the legislature and the judiciary. Third, pick up the judiciary, understand how the judiciary is separate and how the judiciary interferes with the executive and the legislature. This becomes the primary focus of this class, and let's understand why that is the case. And as far as our issues are concerned, this becomes a stitching exercise because we've covered all of these issues already in our earlier themes, and these issues are effectively sort of hinged on the larger issue of separation of powers. For example, you would remember when we studied the executive, we looked at the larger issue of ordinances. And ordinances in our previous year questions also have always had an element of separation of powers mentioned in the previous year questions as well. Similarly, you would have heard of something called delegated legislation, which we had studied partially in the executive, and we had also given a reference in our lectures on the legislature. So even delegated legislation is an application of what is called separation of powers. Similarly, when you look at legislature, we had studied in a fair bit of detail the issue of office of profit, and office of profit also happens to be based on the principle of what is called separation of powers. In fact, it was a reform recommended to anti-defection law is also based on whether the speaker should be the adjudicating authority or not, has an application of separation of powers. Then when we look at the judiciary, when we look at judicial review, judicial activism, when we look at the larger issue of judicial legislation, this also becomes an issue of what is called separation of powers. Similarly, when we look at judicial independence and we look at the larger issue of appointments and transfers, etc., etc., these are also applications of separation of powers. So the point that I'm simply trying to make is that the issue based applications of separation of powers and checks and balances we've already covered, and questions are asked with a focus on this issue and the context being separation of powers. This is reversed in themes where the focus is separation of powers. The context could be one of the three branches. Say, how does the parliament keep a check on the executive? Or what is the role of separation of powers in Indian democracy? And so on and so forth. So the way the questions are asked is functionally different. In a thematic approach, it's a more theoretical element. In a more issue-based approach, it's more contemporary, where they ask you a specific issue and say, for example, in ordinances, while justifying the rationale behind ordinances to be separation of powers, do you think ordinances can be repromulgated indefinitely? Should we even have ordinances or not? We've done these questions and we've done these topics in our earlier lecture. So this becomes sort of a stitching theme in its eminent domain, in its categorization. So therefore, when we study separation of powers, we study separation of powers from a thematic point of view as far as this particular lecture is concerned. And almost each of these we've discussed through our PYQs, and we've discussed them substantively in our earlier lectures. And you'd be surprised to note that from here, there has only and only been one question that has been asked. And the question was, do you think that the Constitution of India does not accept the principle of strict separation of powers? Rather, it is based on the principle of checks and balances. Explain. The reason this was asked in 2019 is because the slew of ordinances that were promulgated, there were certain directives that were given by the Supreme Court on certain environmental issues. As a consequence of this, the larger thought of separation of powers was to be asked. Now, if we go back to the concepts of separation of powers, it always comes back to our original flowchart that we've been sticking with. It all starts, as we've spoken about on numerous occasions, is with rule of law. We understand rule of law to have three pillars: absence of arbitrary power, equality before law, and predominance of legal spirit, all of them tend to perform what is called a limiting function, therefore giving rise to the principles of constitutionalism enshrined through the constitution, which would therefore have certain key branches, which could mean the fact that you have a written constitution, the fact that we have parliamentary democracy, the fact that we have separation of powers and therefore checks and balances, the fact that there is judicial review, the fact that there is to a larger extent judicial activism, and the fact that there is an element of federalism. So again, we use permutation and combinations, and we figure out that separation of powers becomes our key theme. So essentials of separation of powers would mean you should technically have a written constitution. It helps in safeguarding parliamentary democracy. It allows for greater judicial review, and from a vertical standpoint, it also emancipates the larger idea of federalism. So that's the basic purpose, that's the basic understanding of it. And from a core rule of law perspective, you will generally see if powers are categorically divided, then there are lesser chances of arbitrariness, and therefore adequate actions can be taken. Now, if this is the larger understanding of it, then let us look at, when we look at the syllabus, there are effectively two specific things that are mentioned right at the very beginning of your syllabus. It asks you functions and responsibilities of the union and the states as the first line, and second, issues and challenges pertaining to the federal structure of India. And in continuation, it extends up to devolution and challenges up to the local level and so on and so forth, which is theme number 8, which is local self-government. Now, as far as the syllabus is concerned, very specifically to center-state relations, you have a dedicated component which is categorically mentioned in your syllabus. Now, in addition to this, one specific body, which is the GST Council, has been important in the last 2-3 years. Secondly, the Finance Commission of India also tends to have a federal impact. In fact, the Finance Commission of India has a dual role. First, its role in the federal structure, and two, its role in strengthening government finances, as the questions tell us, government finances at the local levels. And third is, of course, Niti Aayog, which gives you new dimensions to what is called federalism. So these three bodies also have to sort of be done in conjunction with federalism. On top of this, an international comparison with the United States, because the primary country that you should compare your federal structure with tends to be the United States of America. So if you look at federalism and center-state relations as a whole, there are essentially 3 layers to it. The core is federalism and center-state relations. Second, the bodies which have added dimensions to it. And third is an international comparative context between India and the United States. So we've got to keep that in mind. And on the basis of this, let's now understand what our previous year questions tend to tell us. Now, when we look at the previous year questions, as I told you, in the first few years, there are several questions that have come from here. In fact, in 2013, because of certain changes in Karnataka and the region of Telangana, though Andhra Pradesh and Telangana had not officially bifurcated at that time, so because of certain changes in Karnataka, regions of Telangana, Maharashtra and Bihar, what had specifically happened was that larger administrative units called districts were actually bifurcated into smaller districts. Basically, newer districts were being created. And this happened across a few states. And therefore, contemporary affairs or current affairs had become a larger context. And a standard question on big states versus small states was asked from here. Now, big states versus small states is in fact a divided topic between territory and citizenship and federalism. For the mains purposes, we should generally look at it from the point of view of federalism. And a big states versus small states question should generally be answered in three themes or in three headings. First, does it administratively make sense? Second, does it make sense from a welfare point of view? And third, does it make sense from a representative point of view? Now, in 2024, there is not a very good chance of having a question on big states versus small states, largely because nothing major has happened on that front in the last 1 year or so. But the question in 2013 therefore read, many state governments bifurcate geographical administrative areas such as districts and talukas for better governance. In light of the above, can it also be justified that more number of smaller states would bring in effective governance at the state level? And the context, as I already discussed with you, were the creations of smaller districts from larger ones across the board, across the few states. In 2013, there was another question that was asked, and this was, to my mind, a very specific targeted question. The question that was asked in 2013 was, recent directives from the Ministry of Petroleum and Natural Gas are perceived by the Nagas as a threat to override the exceptional status enjoyed by the state. Now discuss in light of Article 371A of the Indian Constitution, which therefore means that you are looking at a specific issue of special states. For example, it could be Delhi, it could be the Northeast, it could be 370, and you will see questions on some special applications of federal structure, certain exemptions to the federal structure, certain aggravations to asymmetric federalism that are often asked in this particular context. Now, what had happened in 2013 was that the government of Nagaland had directly invited what is called an expression of interest from private mining companies to invite some form of expression of wanting to conduct mining operations in Nagaland. Now, the provisions of Article 371A are such that the central government has a larger role to play via its constitutional functionaries for such activities in the northeastern part of the country. And therefore, when the Nagaland state government on its own, at the federal level itself, at the state level itself, invited direct applications from private mining companies, it raised some flags at the level of the center. There were several news reports on it a few months before the mains exam, and this is also the first year where the pattern has changed, which means that one could expect the UPSC also to take some time to gain its ground in realizing what kind of questions that are meant to be asked. Nonetheless, this was the question. The third question was, constitutional mechanisms to resolve interstate water disputes have failed to address and solve problems. Is the failure due to a structural process or a process due to a structural issue or a process inadequacy or both? Now, the reason this was asked is because the final order of the Krishna Water Disputes Tribunal was released. And this, of course, caused a great degree of local unrest and agitation. But there are two very interesting words that are mentioned here: structural inadequacy and process inadequacy. Structural inadequacy means, is there a problem with the composition of the Water States Tribunal, the way the hierarchy, the structure, the jurisdiction of the Water States Tribunal? And process inadequacy is the way with which the Water Tribunal proceeds with deciding cases. The answer, of course, is a bit of both, and there are some challenges with it. And in a few years from 2013, there were certain amendments that were made, and these amendments were also considered to be federally questionable. But this also opens a new dimension to federalism, which means not only are you to look at the larger issue of big states versus small states, or specific special cases of federalism, you also have to look at the thematic points of conflict in the federal nature of our country, which is the interstate water disputes, which of course bars the jurisdiction of the Supreme Court directly and constitutionally under Article 262. So these are the three questions that have been directly asked with respect to what is called federalism. Now, the fourth question I've purposely written here is because this question, though, is not about the federal structure, but the extension of it, which is local self-government. And while the center through the 73rd and the 74th Amendment can give you a structure to local self-government, but how powerful and how effective are local self-governments would largely be dependent on what is called the will of the states, because local self-government tends to be in the state list. So in line with that, in 2013, the question was, discuss the recommendations of the 13th Finance Commission, which have been a departure from previous commissions for strengthening the local self-government finances. So this isn't an overall question on whether the Finance Commission is doing a good job or not. This is a question about how the 13th Finance Commission is different from the earlier commissions in terms of what it has recommended for strengthening the financial capacity of urban and local self-governments. This was generally asked because the 14th Finance Commission was appointed thereafter and will of course come into operation from 2 years from now, 2 years from 2013. But that's the larger context. This is why things were asked. So very interesting insight when it comes to what is generally called the nature of federalism. Now, if you move to the next year, you will see a drastic decline in the number of questions that are asked and a very different approach to it. In 2014, the question was a theoretical question, a question which is an outcome of several federal issues that kept cropping up across the year in 2014. See, the question was, though the federal principle is dominant in our constitution, and that principle is one of its basic features, it is equally true that federalism under the Indian constitution leans in favor of a strong center, a feature that mitigates against the concept of what is called strong federalism. So, the jurisprudential reason behind this is, of course, 20 years to what is called the S.R. Bommai case, but also from a contemporary affairs point of view, there were several instances of precedents rule under Article 356 to have been questionably imposed in Arunachal Pradesh and Uttarakhand, to the extent that the Uttarakhand High Court had in fact reversed the presidential rule and its imposition in Uttarakhand. There were also demands of greater autonomy in some parts of their states by states such as West Bengal, Tamil Nadu, Bihar, and of course the Delhi issue had now becoming to start taking ground. And the GST is going to now be in talks, in policy discussions, and eventually you will see the GST Act to have been implemented in a few years from now. But there were larger discussions on whether GST should be implemented, should we have a concept of it, and all of those things. So there was a bunch of things that happened, and of course there was 20 years to S.R. Bommai, and a theoretical question was asked, and 2024 is 30 years to S.R. Bommai. And S.R. Bommai is a key case in determining the nature of federalism in India, more particularly the emergency. But the idea behind all of this is that in 2014, now they've asked you a theoretical question, which therefore now becomes your starting point when it comes to federalism. In 2015, the question was again theoretical in terms of what is the evolution of federal structure. So, new government had come in 2014, and by 2015, the Niti Aayog was set up. The Niti Aayog that was set up in 2015 as a replacement to the Planning Commission was functionally different from the Planning Commission, in the sense that it involved a more participative decision-making process. It did not have the powers of financial advisory like the Finance Commission, like the Planning Commission, It was basically a planning commission without the blank check that the planning commission had. And the Niti Aayog in its very first year in 2015 had given the concept of what is called cooperative federalism in one of its documents that were released. And based on that, there was a question in 2015. The question was, the concept of cooperative federalism has been increasingly emphasized in recent years. Highlight the drawbacks in the existing structure and the extent to which cooperative federalism would answer the shortcomings. So there are three parts to this question. First, what is the buzz around cooperative federalism? Two, what are the challenges in the existing center-state framework? And three, how does cooperative federalism tend to solve the challenges in the existing center-state framework? And therefore, because of the Niti Aayog and the 14th Finance Commission being appointed, a subgroup of chief ministers was called in, GST was discussed in a more robust manner. So there was, of course, a larger aspect to this. In some years, you will see other variations of this. You will see something called confrontational federalism. You will see something called competitive federalism. You will hear of something called accommodative federalism, which are also asked in the years that follow. In 2016, the question was very specific with respect to the special status of J&K. In 2016, because of the protests around Burhan Wani, because of shutdowns that were being imposed in the state of J&K at that time, because of a larger degree of conflict between the center and the states, 370 and the state of J&K was, of course, a national use for an entire year. And in 2016, the question that was asked from here was actually a fairly existential question, if you may. The question was, to what extent is Article 370, bearing the marginal note, which is in the official text of the Constitution, temporary provision with respect to J&K, temporary? To simplify this question, what this question actually was that how temporary are temporary provisions of Article 370? Discuss the future prospects of this provision in the context of what is called Indian polity. Now let's understand what this means. This means this question is before 370 was abrogated in 2019. This question is about what you think can be the future of J&K. And what is very interesting to note is, once 370 is abrogated, the mains exam wouldn't dare to ask you whether it was right or wrong. The same way, once a Supreme Court judgment is delivered on a rights issue, you're asked an impact of the Supreme Court judgment. You're not asked whether the judgment was right or wrong. This is particularly true here as well. What is the impact of it? You will see this in Delhi versus LG, where once the judgment has been issued, the question is going to be, do you think the judgment solves the problem? And this has also been sort of in news in 2023 and 2024, largely 2023 because of the judgment that came, and the judgment was nullified by a parliamentary action through a law, and where they created an authority in the Delhi state government which would override certain functional responsibilities and powers of the Delhi state government. We'll come to that later. But in 2016, the question was, do you think it is temporary? How temporary is it? Effectively asking you, can 370 be legally removed? It is not asking you, should it be legally removed? It's asking you, is it possible for 370's application to either be completely removed or to be diluted in some form, shape or manner? The second question that was asked in 2016 again is a very interesting question. This question is very specifically on a federal issue. This is when the High Court for the first time, the High Court of Delhi for the first time, had given a judgment in favor of the Lieutenant Governor of Delhi. And the High Court of Delhi had said that because Delhi, according to the High Court of Delhi at that time, and this judgment has been overruled, of course, that Delhi is closer to a union territory than it is to a state, by High Court's reasoning best left to their wisdom, which of course gets overruled by two subsequent Supreme Court judgments. The High Court essentially declared that the Lieutenant Governor has complete control of all matters regarding the National Capital Territory of Delhi, and nothing can happen unless the LG basically agrees to this. And in light of this, there was a question that was asked in 2016. The question was, discuss the essentials of the 69th Constitutional Amendment Act and anomalies, if any, that have led to the reported conflicts between elected representatives and the institution of the Lieutenant Governor in the administration of Delhi. Do you think that this will give rise to a new trend in the functioning of Indian federal politics? Very interestingly, the question isn't about political circumstances, and thankfully so. The question is that Delhi gets to be Delhi because of the 69th Amendment, which inserts specific provisions in the Constitution in the form of articles. Now, what are the basic additions that were made by the 69th Amendment? Are there some loopholes or certain loose ends in the 69th Amendment? And is it because of the 69th Amendment and because of the loopholes of the 69th Amendment that there has been a greater grey area, which has therefore led to a conflict between the center and the state effectively, because the Lieutenant Governor is appointed by the center? And do you think that this particular problem is going to now shape the discourse of federalism in the country? To my mind, it was a tough question, because what the question was asking versus what students were generally writing were two very different things. The question always asks you very basic things. Whenever, and you'll notice this about specific questions. Whether it's a 370 question, whether it's a 371A Naga question, whether it is a 69th Amendment question, you will see that whenever there is a federalism question on a contemporary issue, the federalism question on a contemporary issue is always, as a matter of fact, no matter what the case might be, is always very basic in nature. The complications will come in the evolution of federalism, the dimensions of federalism, because they expect the students in a contemporary issue to be aware of the basics of a contemporary issue. They don't expect the students to have that academic expertise, because honestly, the contemporary issue is also evolving in its own right. And that's largely the reason behind it. And that's the 2016 question. Then in 2017, because now the GST has been passed and we have the 101st Amendment, you now get your first question on GST. So by the same logic, 6th schedule is in the news. You are supposed to know the basic provisions of the 6th schedule. What are the primary issues with the basic provisions and how would you solve them, which we will cover in this lecture itself. Now 2017, explain the basic features of the 101st Amendment Act. Do you think it is efficacious enough to remove the cascading effect of taxes and provide for a common national market for goods and services? Now, to remove the cascading effect of taxes and to provide for a national common market for goods and services is officially the stated objective of why the GST was brought in the first place. And again, if you see, this is a contemporary issue. They haven't asked you whether it's going to work or not. What they've basically asked you is, these are the provisions. Now could you please tell me, will these provisions help in attaining the larger objective that there is? Going back to the drawing board. In 2018, there was another question. And this question now is because of the Supreme Court judgment. Now, whether the Supreme Court judgment of July 2018 can settle the political tussle between the Lieutenant Governor and the elected government of Delhi. Now, this question was asked in the context of the Supreme Court judgment as mentioned in the question itself. What the Supreme Court in 2018 basically said was that the Lieutenant Governor cannot act independently and must take the advice of the Council of Ministers, because there is an elected government, there is parliamentary democracy even in the region of Delhi. Now, by that logic, in 2023, when there was another Supreme Court judgment, there should have been a question. But unlike 2018, immediately post the 2023 judgment, there was a parliamentary action to sort of dilute the Supreme Court judgment. And two, the 2023 judgment was very specific about who has control over the administrative officers in the state. And while it is an important issue in governance, to have a larger question like this in the mains exam does not give it reason enough to be a singular question. Nonetheless, in 2023 Magna Carta also, if you want to go and cross-reference the notes, I had covered this just to be sure, including the parliamentary authority that was being, the authority that was made by parliamentary law was also covered. Anyways, now from 2018 onwards, you see a different set of questions that are asked. You see more academic questions that are asked. In 2019, the question is, from the resolution of contentious issues regarding the distribution of legislative powers by the courts, principles of federal supremacy and harmonious construction have emerged. Explain. Now, this to my mind is more of a legal question than it is a general studies question. The context behind this is, of course, the 15th Finance Commission was being formulated and was also tasked with the purpose of re-examining and restructuring the centrally sponsored schemes. There were also issues of Delhi statehood. There was also a judgment on the internal conflicts between the Customs and Tariffs Act, which was delivered by the Supreme Court. But this is still a theoretical question. It is still a question that should be done irrespective of contemporary affairs or not. The question was a fairly simple one. The question was, there are issues with legislative relations between the center and the states. And center-state issues have to be heard by the Supreme Court as a part of their original jurisdiction under 131. Now, in the process of the Supreme Court solving the issues of legislative conflict, the courts have come up with the principle of federal supremacy and harmonious construction, which basically means, in terms of when there's a conflict between the center and the state laws, and two, the doctrine of harmonious construction, as much as possible, try to make sure both of them work together. Try to make sure that one doesn't have to go back. Now, the principle of federal supremacy is often misunderstood. Federal means national supremacy, which means if there is going to be a conflict, the national law will prevail over the state law. And before reaching to that state, let us try to make sure both laws work harmoniously if there is no primary conflict between the two. And this is why this question was asked in 2019. It also is a very standard theoretical question on conflicts between the center and the state. Good question, theoretical question, but often misunderstood. Now from 2020 onwards, 2020, 2021, you have two questions being asked from this topic. The first question that was asked was again an evolutionary question on federalism. How far do you think cooperation, competition and confrontation have shaped the nature of federalism in India? Cite recent examples to validate your answer. So to put it simply, cooperative federalism is where the states work together and the center and the states work together for larger good objectives. Competitive federalism is where the states compete with each other, perform better on certain indicators to garner better central incentive. Confrontational federalism is where the states have issues with each other and there could be also an instance of an issue between the center and the states. And the question was, how have all of these three instances affected the nature of federalism in India? Now, this is of course asked in the context of a larger number of things, such as the abrogation of Article 370, the imposition of the Citizenship Amendment Act of 2019, the NIA Act which was passed, the National Investigative Agency Act The question was also pertaining to the goods and services tax. It was also about the sustainable development goals. So the Niti Aayog had published something called the SDG India Index, which is the Sustainable Development Goals India Index, and it also launched a program called the Aspirational Districts Program. And therefore, as a combination of all of these things, this particular question was being asked because of aspirational districts, because of SDG India Index, and so on and so forth. And this is why there was a larger question on the theory of what is called competitive, cooperative, and confrontational federalism. Now, the second question that is asked from here in 2020 is this. A specific question because of the pandemic. And I remember in those days on my YouTube channel, I had done this before the mains exam. The Indian Constitution exhibits centralizing tendencies, very similar to principle of federal supremacy, very similar to a previous question that was asked, which is again theoretical in nature, which is about, do you think the Indian Constitution, do you think the federalism, do you think the federal structure is largely dominant? So these kind of questions have been largely asked as far as what is called federalism is concerned. Now, once we understand this, and once we understand the larger nature of this, we should therefore be able to answer a question on its relationship with the pandemic. So in 2020, the question was, because of the pandemic, there were basically two laws that were in play. One was the Epidemic Diseases Act of 1897, and the second was the Disaster Management Act of 2005. And under this, several pandemic measures were being enforced, whether it's a lockdown, movement restrictions, trade commerce restrictions, so on and so forth. These restrictions that were being imposed under these laws tend to generally have an impact on federalism. In addition to this, it also saw the passage of the Farm Law Acts, which, though was in the central domain, was largely argued to be non-participative or non-inclusive in nature. So therefore the question was, do you think we are centrally stronger than the states so that there is unity and integrity of the nation? Now in 2021, a few months before the mains exam, there was a question very specifically to a body. Now the question, this does not make the CBI important. The question was, the jurisdiction of the CBI regarding lodging an FIR and conducting a probe within a particular state is being questioned by various states. However, the power of the states to withhold consent to CBI is not absolute, explained with special reference to the federal character of India. Now, this was a particular issue very heavily reported in the news with respect to the conduct of the CBI. What had basically happened was that in our corruption jurisprudence, in our corruption legal system, what basically happens is this. For you to prosecute a person holding a certain office, you would require permission from the person above that person. You would require permission from a senior official. This is called prior consent. But if the prosecuting authority is the Central Bureau of Investigation, then that prior consent is not needed. However, under certain scenarios, the state governments can still withhold the conduction of a CBI inquiry because sometimes it would be argued that the CBI inquiry may be politically motivated. And in 2021, particularly in the cases of West Bengal, this was a larger issue. And therefore this question was asked. Does this question become relevant today? Absolutely not. Does this mean we have to do an analysis of the Central Bureau of Investigation? No. The question was about how the way the CBI works, or largely the way the corruption ecosystem works, that has an impact on federalism. Then the second question that was asked in 2021, again, the second question from the same year, is how have the recommendations of the Finance Commission enabled the states to improve their fiscal position? Now, for the 14th commission to be asked in 2021 was a matter of surprise. One can now, in a post-mortem manner, discuss and say that no, the 14th commission reports were being discussed, their implementation status was being checked. Why we Reddy had made some comments, which was in the newspaper. Agreed. But they're too minute an extraction to be important for the mains exam. But the question was actually a fairly simple one. What is the impact of the 14th Finance Commission to improve the financial status of the states, the financial ecosystem of the states? And that was what the larger question was. Now, 2022 was a blank year, but in 2023, there were two questions that were asked. In 2023, the first question that was asked had an opinion embedded in the question. Almost 30 years to what is called SR Bommai, of course, is a triggering factor. SR Bommai therefore becomes extremely important for us this year as well. But the question was, account for the legal and political factors responsible for the reduced frequency of using Article 356 by the Union government since the mid-1990s. The mid-1990s is post SR Bommai, because SR Bommai is a 1994 case. Nonetheless, the reason this 1984, yeah, so it's a 1994 case. Now, the reason this therefore becomes important is because the question has political factors which have also been mentioned. Now, the reason we are saying it has political factors is that the enumeration of political factors becomes complicated. Account for the legal and political factors. So your legal factors would be, what are your constitutional provisions? What were the amendments that were made? What are your major Supreme Court judgments? Those are your legal factors. Your political factors would be change in the nature of government, change in whether we have coalition governments or not, change in voter dynamics and regional party behavior in the states. That also has an impact. So this is a question partly of emergency and partly of electoral and voter behavior, which has to be combined in a certain manner, which is why this question was specifically asked in 2023. The next question that was asked in 2023 is, explain the significance of the 101st Amendment Act, 5 years of GST on 2017 plus, and to what extent does it reflect the accommodative spirit of federalism? The accommodative spirit of federalism is a subset of cooperative federalism, where cooperation could mean active and passive and working towards a good goal. Accommodation would be giving up certain domains of your own so that you could work in conjunction for the larger good. There's a minute difference. Nonetheless, so there was a GST question that was asked, which means if you look at the sheer nature of questions that are asked, you understand that there are certain parts to this. You need to know the basics of federalism. You need to know at an umbrella level the state of federalism in the country. Then you need to know specific instruments of center-state relations. Then you need to know specific applications of contemporary issues. Now in 2024, GST is not going to be asked because it was asked in 2023. We could use it as something in the larger scope of things, but nothing beyond this. So for 2024 mains, we have to prepare this. Local self-government or panchayat or municipality is technically explicitly nowhere mentioned in our syllabus. What is mentioned in our syllabus is this. The word is devolution, and it talks about two kinds of devolution: devolution of powers and devolution of finances, and what are the challenges with respect to devolution up to the local level, which means it's an extension of center-state relations and going beyond states, which is therefore creating a new third tier of government. Now, in the garb of all of this, there are some topics which are interrelated. It is in here, and because we're generally talking about finances, we should also be referring to some important recommendations or the role which is generally played by the Finance Commission of India. In fact, I have purposely kept Finance Commission to be done in the body section of governance, largely because Finance Commission is asked in two ways. One, its aspect with respect to center-state relations. Two, its aspect with respect to local self-government. And three, Finance Commission as a whole. And we have a new Finance Commission, the 16th Finance Commission, which has been appointed now, and they will be giving recommendations for a period that's going to come forward from now. So we'll come to that in just a bit. And Arvind Banagri, I think, is heading the 16th Finance Commission, and we'll come to that eventually. But the idea is, when we do local self-government, we have to focus on our keywords, because our keywords in the main syllabus is exactly why questions are asked in a certain manner. Now, if you look at the kind of questions that are asked, you would understand a certain length and breadth, and you would understand a certain pattern to which the questions are largely being framed out of. So let's look at the questions. In 2013, the question was, discuss the recommendations of the 13th Finance Commission, which have been a departure from the previous commissions for strengthening local government finances. Now, the same question technically can be asked in 2024, because you have a new Finance Commission, and the recommendations of the 15th Finance Commission anyways have been greatly discussed and debated. The context is the same. A new 14th Commission was appointed in 2013. So as you can see in this particular question, the question has largely been about how the Finance Commission of India is playing a role within its mandate under Article 280 to strengthen local government finances. So this question becomes an FCI LSG question. In 2015, they've skipped 2014. In 2015, there was a question. In the absence of a well-educated and organized local self-government, panchayats and samitis have become mainly political institutions and not effective instruments of governance. So if you think about it, they've given you two parameters, education and organized, and then the question has largely been that they have not become an effective instrument of governance. So the idea is, local self-government is not helping in governance largely because of lack of educated people, lack of organization, and in fact has become a political system. This largely calls for a critical analysis of the larger ecosystem of what is called local self-government, and that's something that we have to focus on again this year also, because there was a technical question that was asked in 2023. The reason this was asked in 2015 is because the states of Haryana and Rajasthan both had imposed certain educational qualifications for panchayats. Now, again they've skipped a year, and then in 2017 they've asked a question. The local self-government system in India has not proved to be an effective instrument of governance. Critically examine the statement and give your views to improve the situation. The 2017 question, if you notice carefully, is a larger umbrella question of the 2015 question. And the reason this was asked is because you're nearing the 25th anniversary of the two critical amendments, the 73rd and the 74th amendments. If you look at 2018, the question now becomes a little more targeted. The question was a very simple one, and let's understand what it is in terms of what was being asked. In 2018, the question was, assess the importance of the panchayat system of India as a part of local self-government. Apart from government grants, what sources the panchayats can look out for financing developmental projects? If you remember your main syllabus, If you add powers and finances, it becomes a tool of governance. With finance, it's just about financial autonomy. And devolution of finances is the key of the 2018 question. And the reason this was asked in 2018 is because a standing committee on rural development of the parliament had submitted its report on the improvement of the functioning of the panchayats in 2018, where they had recommended certain innovative sources wherein allowing for certain grants that could be made to local self-governments as a part of CSR initiatives of corporates. It had also recommended that there must be a greater promotion of what are called municipal bonds, and if municipal bonds can exist, then can we also have panchayat bonds in equivalent capacity. So as you can see, the questions have largely been on the whole, or they have very specifically focused on the financial aspect of it. Now, if you see 2019 onwards, there is a little more precision to the questions that are asked, and sometimes they get back to their original form. In 2019, the question was the reservation for seats for women in institutions like local self-government has had a limited impact on the patriarchal character of the Indian political process. Now, why was this question asked in 2019? The reason this question again was asked in 2019 is, again, you have an anniversary mark for the 73rd, 74th Amendment, but there was a larger discussion for reservation of women in the seats of the parliament in 2019, and that had almost come to a standstill. At that time also there was a women's reservation bill of 2008, which was again stalled, and it did not find support of the Lok Sabha eventually. And what had generally happened is several political parties, to sort of emancipate intra-political democracy, had announced that X percentage of seats that will be given to candidates from their political parties for national and state elections would be reserved for women. Now, this becomes even more important now in 2024, is because in the context of the new reservation of women in parliament, you could be asked that now that if you can give reservation for women in parliament, has the reservation in local self-government actually worked? If that hasn't worked, do you think the other will work? Or do you think this will help reservation in local self-governments to become slightly better? And the concepts of Sabhapati, etc., would therefore be rarely seen. So the larger aspects of functionality are going to now come into light. In 2020, that picked this up from the economic survey also back in the day. But the question was, the strength and sustenance of local institutions in India has shifted from their formative phase of functions, functionaries and funds to the contemporary stage of functionality. Highlight the critical challenges which are faced by local institutions in terms of their functionality in recent times. Now let's understand this largely. See, they are using three specific terms: functions, functionaries and finances. These were the original terms to evaluate local self-government. Now you have a fourth F, which is functionality. And if you can analyze local self-government on these 4 points, there's really nothing more that you can write. So the question was, understood that you're giving them enough funds, they're giving them enough functions, you perhaps may be even giving them enough functionaries. But have they really become functionally important? Are they some institutions, or there are some levels that we can truly bank upon? Is it that they're solving a certain purpose? The larger existential value of local self-government was specifically asked in the 2020 question. And that is why, and this is also in the context of the pandemic, because the panchayats had played a tremendously important role, and the Panchayati Raj Ministry a year before had come up with the devolution index, which basically ranks states on how efficient they are when it comes to panchayats. So, of course, there is a context to these things. Then you have the year 2022. They've skipped 2021 again. To what extent, in your opinion, has the decentralization of power in India has changed the governance landscape at the grassroots level? Celebrating 30 years to the 73rd, 74th Amendment, give or take a year or two. If you think about it, this again is an overall umbrella question. It is asking you to completely evaluate. Remember 2015, 2017 questions? This is a similar question that has been asked in 2022. Now in 2023, they've gone extremely specific, very, very technical for the first time. Now, there was a reason behind this. The states in India seem reluctant to empower urban local bodies, both functionally and financially. As far as the financial aspect is concerned, the Reserve Bank of India, just a few months before the mains exam, had actually released a report on the working of municipalities, specifically urban local bodies. And it had spoken about how finances can be strengthened, where are the primary problems. It had also largely spoken about devolution and everything. So a report of the RBI was primarily the basis of why this 2023 question was asked. In addition to this, the urban city rankings were also released by the Ministry of Housing and Urban Affairs, and you cannot have better urban governance without strengthened urban local bodies. Also, you had the first ever investment grade municipal bonds that we were talking about from the Standing Committee report were also officially listed by the National Stock Exchange. And of course, there was the larger RBI issue that we spoke about. So the 2023 question, to my mind, was a specific trigger question on something that specifically happened. Now, if in 2024 at all there has to be a question, now one must remember, local self-governments have been largely infrequent, which means if they've been asked for a year or two in consequence, they are generally missed the year after. So therefore, if I have to look at a set of questions, this is what we would generally answer these questions to be. Firstly, in 2024, a question on local self-government generally seems to be slightly unlikely. I'm not saying it is impossible, but it seems slightly unlikely. And what we must prepare under all circumstances to just be on the safer side is an overall analysis of the local self-government, both from a rural and an urban point of view. And we must cover all the 4 F's as clearly as we can: functions, finance, functionaries, and functionality. If we are able to do this rightfully, then we will be able to get a full answer ready as far as our ecosystem is concerned. And this is something that we have to do under all circumstances. So this is our overall analysis. Now, having said that, it's equally important to understand the applications of local self-government in several other areas. In GS paper 1, when you're generally writing an answer on regionalism, one of the ways to validate, to respect local sentiments is to empower local self bodies or local governing bodies. Second, when you are largely facing challenges of urbanization, which is a part 1, part 3 question, you must be able to do this by resorting to certain local practices that can only be enforced at the local level through certain local governance institutions. Third, when you're writing a larger answer on federalism, true autonomy is only reflected by instruments and the true usage of what is called local self-government. In fact, if you're looking at a larger answer on climate change, if you want to have sustainable local practices and true change at the ground root level, you would require some amount of emancipation of the local self-government. So while local self-government in isolation can sound like this, but it also has a very important role to play in certain 4 different aspects of your other parts of general studies. notwithstanding the fact that we would also be giving some reference to the Finance Commission of India and its role when it comes to the local self-government. Now, I've obviously given you the notes which cover almost everything that we need to do as far as our lecture on local self-government is concerned. And like all lectures, I will keep referencing the notes with specific page numbers and headings that we have to keep going through. But largely, this is something that we must be able to do well. See, it's very crucial for you to understand that now is the time, because the toughest parts are over. Now is the time that you start really interlinking and making larger elements to things to be done right in a certain manner. Okay, so we'll start with the structure and we'll start with the first particular topic of as far as what is local self-government and how do we need to do this right. Now, when we prepare local self-government generally, we should be therefore answering some very basic fundamental questions. The fundamental questions that we're generally looking for when we're trying to answer local self-government, this should be done in a certain manner, and let's understand what it is and what needs to be done. See, first things first, we must be able to answer what is local self-government. Thereafter, we will move on to answering what is the vision of local self-government, which was largely a Gandhian principle, which was also inserted through our directive principles. Then just a quick overview on the committees that have led to the building of local self-government from a rural point and an urban point. We will also then understand what is the current status quo, what are the laws that govern it, what are the other supplementary provisions, where does it apply, where does it not apply, what are the compulsory voluntary provisions. We will very specifically also look at the PISA Act of 1996, which makes sure that larger provisions with an empowered status of the Gram Sabha is applied to certain sections in what is called the fifth schedule part of the country. Not the entirety of the fifth schedule, but some parts which are covered in the fifth schedule. Thereafter, we will move on to the local self-government part of it, and we'll understand what the key terms are, technicalities are, what the laws are, and we'll do a critical analysis of the larger issues. We should also be generally focusing on the financial aspect of it. And in this particular lecture, I'll give you two diagrams. One, particularly on the structure and the positioning of local self-government. And two, I'll also be giving you one specific diagram covering the sources of funding, both from a thematic point of view and also from a legal point of view, from a provisions point of view, as far as local self-governments are concerned. And they have to therefore be done in that very, very specific capacity. So we'll start with local self-government in just the next segment. When we look at bodies, we should be looking at understanding how are generally bodies asked. See, what ends up happening is, when we look at bodies which are largely to do with, say, constitutional functions, you will generally see a standalone question which is asked on the body, which would cover all aspects, a functions aspect and a structural aspect. Generally, what happens is there are three kinds of questions that can come from bodies. The first question would be the overall analysis of the body. Second would be the structure of that body in terms of who's appointed, what are the powers that people have. And the third is a specific question on the functions of that body. Now, if you're generally dealing with bodies which perform constitutional functions, and they not necessarily have to be constitutional bodies to perform constitutional functions, but generally you'll see most constitutional functions are performed by constitutional bodies. So you will generally see a standalone question focusing on the body itself, and you could also see a question specifically on the structure, or you will generally see a question specifically on the functions. This is something which is fairly unique to bodies which are closer to the polity side of things. But if you see questions pertaining to bodies from governance and social justice, you will see bodies which are generally asked overall as a standalone in terms of what is the impact of the body, and you will generally see questions which are asked from a functions perspective. Are they doing a good job? What is the impact? How can we make them better? And so on and so forth. And the difference here also is, in governance, you will largely see questions pertaining to functions. But in social justice, you will see functions and larger open-ended extrapolatory questions as well. So therefore, what ends up happening is, and this is where the crux of the matter lies, by understanding previous year questions, we will be able to understand the kind of questions that are asked from bodies, and therefore we'll be able to place bodies accordingly. So what will happen basically is that now we're going to deal with sections, for example, pertaining to bodies. Then there's going to be a separate categorical section that we're going to deal with, which is about, say for example, vulnerable sections. Then there is going to be something to do with social sectors per se, right? Then there's going to be something to do with good governance, and within good governance you will have regulatory governance, you will have electoral governance, you will have transparency and accountability or anti-corruption governance, you will have corporate governance, you will have environmental governance, and so on and so forth. So depending on the kind of the body that has been asked, we should be able to figure out the kind of questions that have to be answered, right? So for example, vulnerable sections and social sectors would largely come under the domain of social justice. This would largely come under the domain of governance. So you will generally see from our previous year questions that bodies that can be placed here or here will be placed here, and whatever is left over, whatever is a standalone question, will generally be covered in this context. Just to give you a brief example before we get into things. So for instance, the Election Commission of India, the Competition Commission of India, for instance, let us say the Central Information Commission based on the right to information, for example, the Securities Exchange Board of India, all of these would largely be covered from a pure functions perspective. Are they doing a good job? What more can be done? If there's anything that is not letting them do their good job, how do we solve that problem? But when we look at, say, issues from here, such as National Commission for Scheduled Castes, National Commission for Backward Classes, National Commission for Women, NHRC, you will see very existential extrapolatory questions. You will see questions to the account that says, oh, do we make the NCW a constitutional body or not? How can the NHRC assist the judiciary better? It's very functions based. Has the NCSC done a good job? Can the NCSC assist in enforcement of reservation to an institution that it doesn't? And then you will generally see bodies like the CAG, the Finance Commission of India, certain legal bodies such as Attorney General. They will come here because this is a standalone full analysis. So this is generally how you should always deal with bodies in a certain manner of speaking. And this also gives me the opportunity to deliver a peek into what comes ahead. What effectively I'm trying to convey is that, for instance, Representation of People's Act, electoral reforms, all of those things will come under a larger segment under good governance, which is electoral governance. It's not just about the body, it's about the body trying to fulfill a larger purpose. So MCC and everything comes there. Under the garb of corporate governance, you would also discuss maybe the role of SEBI, maybe the role of the National Companies Act, CSR, all of those things come there. And of course, CSR and the Companies Act become important because we are post the 10 years landmark. So there is a way to do this. There is a method to the madness, is all that I'm trying to say. And that method to the madness must always be sort of adhered to as much as possible. Now, to understand this hypothesis, let us always have a framework of bodies that we are dealing with. And this is something that will make things a little better. So, from a formative point of view, You'll have a statutory body, a constitutional body, and an executive body. I'm sure all of us understand that a statutory or constitutional body is a body which has provisions in the constitution, and there are certain protections that are given to that body constitutionally so that it can perform functions essential to uphold constitutionalism, which is why, for instance, the delimitation commission may not necessarily be a constitutional body, but the comptroller and the auditor general is. Similarly speaking, the speaker is not a constitutional body, but you would say the election commission is. So a constitutional body tends to be a body whose provisions are categorically mentioned in the constitution, those foundational provisions, and they are performing certain essential functions to uphold the spirit of constitutionalism, and the constitution therefore gives them certain protections to perform the functions that they have been outlined to do in the constitution itself. That's the larger idea, that's the larger purpose behind it. A statutory body is a body which is backed by law. Now the idea is both constitutional bodies and statutory bodies have a legal backing. The law in case of a statute is an ordinary law. The law in case of a constitutional body is the Constitution of India. And this also gives bodies greater powers to perform certain functions, to perform certain type of responsibilities, and we'll come to that eventually. And then you have executive bodies which are set up directly by the government, by the ministries, by an executive order, and so on and so forth. They're generally called executive bodies. Though a body could be constitutional, statutory, and executive, this is from the formation point of view. Now, then you look at the larger purpose. Now, sometimes bodies have to be regulators. Now, a body is a regulator when the body performs two functions. One, it gets to decide the rules of the sector it is regulating, and two, it also gets to decide, to a limited capacity if not more, certain issues and disputes and conflicts that can come within the sector itself. And that's what a regulatory body is, and that's why regulatory bodies have been asked a fair number of times in our mains exam. So the purpose could be that they're performing a regulatory function. They could sometimes be performing a separation of powers function, that you've created that body so that it's not interfering with the executive, it's not interfering with the legislature, it's bridging that gap. Sometimes bodies are performing a checks and balances function, like the CAG performs an accountability function, and therefore an accountability function is a checks and balances function, simply and effectively. Then you will see something called an expertise function, that sometimes you just need advisory support from the best of the minds in the country to give you categorical expert advice on what should be the way forward. And for that you have certain expertise bodies, or certain bodies which bring in that kind of depth of knowledge, that kind of depth of understanding, and so on and so forth. And this is from a purpose. And then you have a third way to look at bodies, which is effectively the broad powers that the bodies have. So you're either having judicial powers or quasi-judicial powers, or you don't have quasi-judicial powers at all. This has also been categorically mentioned in the syllabus, and we've had a theory question also, is that what do you mean by quasi-judicial body? So the basic understanding is this, that there are essentially two fundamental questions that one has to answer. The first question is a question of fact. The second question is a question of law. Now, a question of fact is a fairly clear-cut question. The question is this, and as simply as it could be, the question is this: did something happen is a question of fact. When that something happened, is that a violation of the law, is a question of law. So question of fact versus question of law is something that we have to very categorically focus on. So a body which performs both of these functions is generally a judicial body. A body which performs at least one of these functions is a quasi-judicial body. They may not have advanced powers of the interpretation of law, they would not have advanced powers of judicial review, but they would definitely have some limited powers on determination of disputes. That's what generally makes a quasi-judicial body a judicial, the body that it is. So that is the third way to look at it. And fourth, of course, is a thematic way to go about it, which is how we generally structure our understanding. So from an electoral standpoint, you will have three bodies: the Election Commission, the State Election Commission, and the Delimitation Commission. Now, if you think about it, for the mains exam, you don't have to particularly worry about the State Election Commission, because it is it's a point in a larger answer on making local self-government better. Delimitation Commission is specifically to deal with adjustments in territorial the extents of constituencies, to the fact that these delimitation commissions to a very large extent cannot under any circumstances be judicially reviewed in terms of the decisions that they have taken. Right? Simple enough, categorical enough, no problem. Delimitation Commission becomes a classic question for the pre, but for the mains, not necessarily so. And Delimitation Commission was asked in the prelims. I will still cover Delimitation Commission in electoral governance just to be on the safer side, because of it being asked in the prelims this year. And you never know, the UPSC, they can ask you a 10 marker and saying, what is the Delimitation Commission, what are its functions, how can you make it better? That could be a larger question, because there have been issues with respect to delimitation. Now we move to recruitment themes. With recruitment, you have the Union Public Service Commission and the State Public Service Commission. Now, till today, there has not been a single question on UPSC and SPSC, either in the prelims or in fact in the mains. And categorically for mains 2024 also, I do not see any reason for a question on recruitment to be asked categorically or specifically. However, what you would be asked is a larger question on civil services reforms, which becomes a part of good governance and bureaucratic good governance. And one of the parts is, how do you make the civil services better? How do you make the civil services more compliant, and how do you make them more efficient and more productive, and so on and so forth. So that's something we've got to remember. Go back to the orientation and think about how we've divided our lectures. So there's bodies, there's regulatory, there is development policy, non-state actors, and so on and so forth. So of course we've done it in a certain way. Then you have financial bodies, and here we can use some intelligence. I'll show this with previous questions as well. The CAG has not been asked in a long time. And generally, whenever the CAG is asked, it's asked in and around an electoral cycle. So CAG becomes extremely important. Last year, they've already asked GST, so GST is out. State Finance Commission is something we will have to not worry too much about, because it is a sub-part of a larger question on local self-government. However, because they've already asked GST, they tend to have a soft corner for the Finance Commission. We have a new Finance Commission that has been appointed this year. The Finance Commission of India therefore has a green flag for mains 2024. So CAG and FCI become extremely important for us this year. Rest could be successfully ignored. Then we come to federal bodies, bodies which help you understand federalism. Now, Niti Aayog, Interstate Council, and Zonal Council. Now, Interstate Council and Zonal Council are almost defunct bodies. At most, there could be a pre-question from here, but definitely nothing in the mains exam. Now, with the Niti Aayog, the body fundamentally is advisory, and the body is not performing an active function in that manner of speaking. So while we do refer to the Niti Aayog for its inputs, for instance, when the Niti Aayog tells us about cooperative federalism, there is a mains question on it, and then we give a reference to Niti Aayog. Or there could largely be a question on the role of the Niti Aayog in federalism, which we've already given and covered successfully as far as our federalism and center state is concerned. But to do a body analysis of Niti Aayog for the mains exam is not important. Now comes the tough part, which is vulnerable sections. Now, this is of course a part of social justice. So, National Commission for Scheduled Caste, Scheduled Tribe and Backward Classes. Now, All of the three to a larger extent become important, and vulnerable sections have to be largely done from a sectoral point of view. So for example, and just to make you understand this, so for example, how we would be doing this is in this manner. For example, we will take caste. When we take caste, we will see if there are any international legal provisions that tell us something about it. We will look at constitutional and legal provisions in and around caste. We will then look at the relevant ministries that work towards, or the bodies, or the relevant ministerial departments that work towards caste upliftment and caste emancipation. We will also look at certain schemes that are in place for improvement of caste issues, and we will then look at institutions generally. And in these institutions, of course, the first is the National Commission for Backward Classes, followed by the National Commission for Scheduled Caste, and so on and so forth. So when you do this in that manner, not only would you have covered an entire vulnerable section, we would have also hyper focused on the National Commission for Backward Classes and the National Commission for Scheduled Tribes. And that's largely a simple, effective way to go about it. So, vulnerable sections. So, therefore, the National Commission for Scheduled Castes become important, tribes become important, backward classes become important, linguistic minorities not so much to be particularly worried about the mains. There hasn't been a language issue in the news. NHRC is forever important. We'll contextualize with current affairs. State human rights commissions work could be merged with NHRC, but a dedicated analysis on SHRC is not needed. National Commission for Minorities becomes important because also in the rights part of it, if you remember, we studied the Aligarh Muslim University. So therefore, this year, the National Commission for Minorities has to be done carefully. The National Commission for Women was asked recently and therefore is of low priority. And the National Commission for Protection of Child Rights would largely make sense in an education review, but nothing specific for that particular point. Now, so this is how we've mapped our vulnerable sections. Then when you look at legal bodies, so to speak, now legal bodies contain the Attorney General, the Advocate General, the Law Commission and the Bar Council of India. When you look at previous questions, you will see there was a question on the Attorney General very recently around the Rafale deal, where the Supreme Court had delivered a judgment and a review petition was not allowed by the Supreme Court. It's also the same year where the Attorney General had written in a couple of editorials views that may not have been in perfect consonance with the government. Now, the primary issue with the Attorney General is that you are a lawyer appointed by the current government, but you are to defend government actions of the past as well. So even if you, for example, have been appointed by the BJP government and the Rafale case is going on right now, and the Rafale case could be attributed, for example, to a previous government, then in that scenario, do you represent to the best of your ability, despite the fact that the actions come from those people who have not appointed you, as opposed to people who you have appointed? So the answer to that is that the Attorney General is the Attorney General of India. The Attorney General is the Attorney General of not the government of India, but the Attorney General of India. So your primary responsibility tends to be with the government, not just the person who's holding government as of today. Now, there is no significant reason enough for us to study legal bodies this year. They are not important. Law Commission and Bar Council of India are largely prelims questions, and law commissions are value adds, but you don't need a review of those. The Advocate General is nothing but a state version, so we don't have to worry about it. When it comes to anti-corruption bodies, which has to be covered under good governance, transparency, accountability, and anti-corruption, extremely important for this year, because we're looking at anniversaries of the right to information, we're looking at Lokpal anniversaries and so on and so forth. So within this, we should be covering Central Information Commission and State Information Commission under the larger aspect of RTI. And because we're doing RTI, we should also therefore be doing the larger analysis of how we can strengthen the RTI framework. A question on the Central Vigilance Commission for the mains is a little unlikely, because the Central Vigilance Commission largely happens to be an apex body. We'll give a reference to how the anti-corruption ecosystem allows for the Central Vigilance Commission to exist at the top, but there's nothing functionally about the Central Vigilance Commission that has been in the news in recent times. CBI was already asked previously in terms of special consent. We've discussed this in Federalism. There is no need for us to worry about the CBI. Lokpal and merging into Lokpal, Lokayoks have to be done because of anniversary years. So this becomes important, and this is how we would be doing our anti-corruption bodies. Now comes the tough part to get right: regulatory bodies. Now, technically, there are so many, whether it's electricity, transport, highways, and so on and so forth. But we generally look at sectoral regulators. We've had questions on should SEBI and IRDA be merged. Last year, we had a question on the Competition Commission of India. And we've had previously, I think in 2014, a question on the Rail Tariff Authority. We'll go through the questions and I'll tell you how questions are also phased in a very nuanced manner. This year, to the best of my understanding, I think because Competition Commission has already been asked, regulatory bodies is asked in a very spaced manner. So for Mains 2024, regulatory bodies become very, very unimportant just for Mains 2024, but we will still do an overall analysis of regulatory governance and merge a lot of other aspects to it, because there have been general questions on regulatory governance also. There has been a question in the past years where the question has been, should regulatory bodies essentially be autonomous, and how important is for a regulator to be autonomous? Now it sounds like an extrapolatory question, but when you have to write about 250 words or 150 words on it, it is an uphill task, and one would require a fair degree of prior knowledge. So such is such. So with regulatory bodies, given the fact that SEBI was in the news recently, I do not particularly think CCI has to be done. Something to do with railways because of the increasing number of rail accidents. IRDA has not been in the news, so we will do an overall analysis of SEBI just to be on the safer side, and we'll of course do something to do with railways. So this becomes my body framework. Some bodies will be done in this theme, some bodies will have to therefore be pushed. So how do we do this? So for example, electoral bodies will be done in electoral governance, which is a part of good governance. We are not doing recruitment bodies specifically, but this is still under good governance and civil services reforms. Financial bodies have to be done purely in bodies because these are standalone questions. Federal bodies don't have to be done. Vulnerable sections have to be done under social justice, vulnerable sections, sectoral overview. Legal bodies don't have to be done. Anti-corruption bodies largely have to be done under good governance, anti-corruption governance or anti-corruption regulation. And regulatory bodies will be done under good governance, regulatory governance. So that is the larger framework. This is how we would tend to effectively get our bodies right. So the idea behind all of this is to be very sure in terms of what we are trying to achieve, because unnecessarily studying all bodies together without being able to correlate what the questions have been will not make any sense whatsoever. And this is where we tend to generally go wrong, which is why if you look at our very specific syllabus points, that's how we've done this. Now what will happen is we'll start with bodies. I have extracted civil services reforms as a separate theme number 11. So from here we'll move directly to, so the idea would be we'll start with FCI, CAG in theme number 10. Then when we do civil services reforms is theme number 11. We'll cover a little bit of tangents to UPSC and civil services. Then we'll move to theme number 12, which is development policy, wherein we'll generally talk about the modes and the methods of development. It's also anniversary years to Aadhaar, so it becomes important. Then we move to theme number 3, which is non-state actors, where we generally cover NGOs, SNGs, other stakeholders, and so on and so forth. And then we move to theme 14, which is good governance, where we look at electoral governance, corporate governance, environment governance, transparency and accountability, and so on and so forth. So what we will largely still try to do is recruitment we'll still do separately, but the rest we will have to merge accordingly to our themes that we've identified as far as our mains Magna Carta is concerned. Now, moving on, let us understand the previous year questions that have been asked, because the previous year questions have been framed in such a manner that will definitely give you some amount of food for thought. So let's move to that element now. Moving on to previous year questions, there are a lot of them, so we must go through them patiently. So in 2013, if you'll see, there are 3 questions, and this is why I keep telling you that the bodies are not singularly positioned. So in 2013, the first question was regarding the Finance Commission. The question read, discuss the recommendations of the 13th Finance Commission, which have been a departure from the previous commissions of strengthening local self-government finances. As we've already identified, that Finance Commission is asked in 3 aspects. First, the larger role in center-state relations, fiscal federalism. Second, how can you strengthen state finances? And third, how can you strengthen local self-government finances? And this was asked in 2013 because the 14th Finance Commission was appointed at that time. So a comparative cursory review. And therefore, this gets tagged to bodies as our theme number 10. Now look at the next question in 2013. The product diversification of financial institutions and insurance companies resulting in overlapping of products and services strengthens the case for the merger of 2 regulatory agencies, namely SEBI and IRDA. IRDA stands for the Insurance Regulatory Development Authority. Now, this is important. The question itself is telling you that there is a commonality in what is being offered in the capital markets and the insurance sector. So that is something you must be first familiar with. The reason this was asked in 2013 is because in 2013 a policy reform was being proposed. It was also categorically earmarked in the economic survey of the time, something called the Financial Sector Legislative Reforms Commission. And it had suggested something called a super regulator, a unified financial agency which will be a single point regulator for all aspects covering finance, whether it's pensions or financial regulators or capital markets and so on and so forth. So this therefore gets tagged in good governance and regulatory governance, where you generally look at corporate governance and financial governance as one of your themes. A tough question nonetheless, but a question that could be answered if somebody had just gone through the economic survey of that year, which by the way I've integrated in the forthcoming themes because that's where there is a context. The third question was a fairly obvious question. A national Lokpal, however strong it may be, cannot resolve the problems of immorality in public affairs. Discuss. This was asked because the Lokpal Act was passed in 2013 and therefore gets tagged to good governance, anti-corruption. Now we're hovering around the 10-year margin, and we've crossed the 10-year margin in fact. So Lokpal also becomes extremely important for this year in 2024. Now we move to 2014. Now there were 2 questions that were asked. One was on NHRC and the second was a very unique question on the Rail Tariff Authority. Now let's look at what the question in 2014 was. The question was this: the National Human Rights Commission in India can be most effective when its tasks are adequately supported by other mechanisms that ensure the accountability of government, which basically means the NHRC standalone is not as effective and can only become more effective if other branches of government, if other agencies of government are supporting the work of the NHRC and therefore bringing in accountability of a government. In light of the above observation, assess the role of NHRC as an effective complement to the judiciary and other institutions in promoting and protecting human rights standards. So this is a question about the placement of the National Human Rights Commission as one of the primary agencies helping in the advancement of human rights. Secondly, its specific relationship with the judiciary of the country. So it is not a question about, oh, there's a problem with appointments, oh, there's a problem with functions. There's a very nuanced element which is asked in this particular question. We would tag NHRC to social justice and in vulnerable sections. But the reason this was asked is because that year the speaker had made some open parliamentary remarks on maintaining a balance in terms of the kind of complaints that the NHRC gets into. Secondly, the Supreme Court in 2014 had taken suo motu cognizance on the basis of certain inputs given by NHRC with respect to certain rights that had happened in 2014. And third is that it was 20 years to the NHRC, the Human Rights Act of 1993, so you're around that margin. So therefore it becomes important to understand it in that context. This is why it is slightly more comprehensive and slightly more important. So you'll always look at anniversary years to these primary bodies so that we can get these questions right. So whenever there's an anniversary year to these kind of questions, which is why 2024 NHRC again becomes important, because you'll be hovering around the same anniversary year. Now, 2014 again, a new authority called the Rail Tariff Authority was set up, and this is a regulatory institution, so gets tagged to good governance and regulatory governance. The question was, the setting up of a rail tariff authority to regulate fares will subject the cash-strapped Indian Railways to demand subsidy for obligation to operate non-profitable routes and services. Taking into account the experience in the power sector, discuss if the proposed reform is expected to benefit the consumers, the railways, or the private container operators. This is far too specific to even be considered worthy of a UPSC civil services question, but nonetheless, within the question they've tried to give you enough information for you to write larger thematic arguments. So the Rail Tariff Authority was set up as an agency to regulate fares. Fares which largely would be run by demand-supply quotients. Fares which would largely be determined on the basis of sustainability. The objection to having a fare regulator within the Indian Railways is that the Railways is itself not a profit-making entity. And the Railways also has a welfareist motive attached to make sure there is last mile connectivity via the rail route. So on the one hand, if the fares become expensive, and fares are not just passenger fares, fares are also fares for freight. So if you are going to make your fares expensive for routes that are less traveled, or routes where there is a lot of demand and you could bring in dynamic pricing, for the railways to operate on unsustainable financial routes, which are largely remote routes, the railways would therefore request the government for some more subsidy or some amount of relief to operate on those unviable areas, which is why this question was asked. So if you think about it, this question is actually a larger question on free market versus welfareism. And all you have to do is answer free market versus welfareism through the Rail Tariff Authority. The larger arguments would remain the same. It's just that you would customize it to the conditions and the specific features that would largely apply to the Indian Railways. Now, moving to 2015, 16 and 17. In 2015, interestingly, we've just had one question. This was a larger overall sort of an arc question. For achieving the desired objectives, it is necessary to ensure that the regulatory institutions remain independent and autonomous. Discuss in light of the experiences in the recent past. Now, this is an overall question. So, something would have happened in the last few years where regulatory institutions have been questioned. So, what has that been? First things first, we've had a bit of a tussle between the Reserve Bank of India and the Finance Ministry back in the day with respect to the constitution of the Monetary Policy Committee. Second, we have an electricity regulator called the Central Electricity Regulator Commission. There were issues with respect to its operations, its transparency and accountability. There were also issues with appointments that were made to the Telecom Regulatory Authority of India and the Securities Exchange Board of India. And in 2015, a remarkable report was released by the OECD, which we also use as a reference point in administrational understanding. The OECD stands for the OECD report stands for basically a benchmark on global standards of good governance, and that is why there was a larger question. And of course, a draft Indian Financial Code was also floated on the floor of the Parliament. It eventually died its own death, which was also about sort of limiting the powers of the Reserve Bank of India. But this is therefore a larger question on A, why do you have regulators? B, how do regulators help in good governance? And C, what do we need to do to make sure regulators are truly beneficial and therefore not just another organization or another cog in the wheel? So a larger analytical question on the larger issue of what is called regulator. So we'll have to keep that in check. Now, in 2016, there were two questions and two fairly simple questions to my understanding. The 2016 first question was on CAG. And finally, something familiar. The exercise of CAG's powers in relation to the accounts of the Union and the states is derived from Article 149 of the Indian Constitution. Discuss whether the audit of government's policy implementation could amount to overstepping its own jurisdiction. So you would generally see CAG has two problems, two functional issues. One is the kind of work it does, and two, who the CAG is. Why is it a single member body? Is it appointed in the right manner? Are the IAS officers demoralized? So there are two functional issues with the CAG. One is with what it does, and second with who the CAG is and how the person is the CAG. So if they've asked what the CAG does now, the next question will be on appointments with CAG, and thereafter the question is going to be either a combination of the two, or there's going to be a singular question again on what the CAG does. Now, the reason this was asked in 2016 is because in 2016 the CAG released a plethora of reports, and this is also in context now because in the calendar year of 2023, the CAG has released just about 18 reports of the audits of the union government. And it is by far one of the lowest number of central audits the CAG has performed in the last calendar year. However, the CAG in 2016 had released reports on the Gram Sadak Yojana, the Food Security Act, and MG Narega. And a PIL was filed on the basis of certain shortcomings which were identified by a CAG report in 2013 based on the spectrum allocation, and there was a further PIL filed which the Supreme Court had effectively quashed. So CAG therefore becomes a standalone body trying to perform a larger function of accountability, and that accountability is achieved through the primary function of audit. So CAG is something that becomes extremely important for us this year, and we would therefore be paying a lot of attention to it. 2016, the next question is, what is a quasi-judicial body? Explain with the help of concrete examples. Now, firstly, it's a theory question in terms of it's being categorically mentioned in the syllabus. I'll show you the syllabus right after this. And the National Company Law Tribunal was set up in 2016, and there was a larger issue with respect to who would govern the tribunals, and we've had a larger discussion on tribunals when we did our theme on judiciary. And of course, there was in the context of a very large number of pendency, which was also crawling up to the Insolvency and Bankruptcy Code, which is also to be coming in 2016. So a larger theory question on what a quasi-judicial body is was asked. Now, would you get a theory question in 2024 on bodies, specifically on the nature of these bodies? The answer is no. because they've not asked bodies in the last 2-3 years. So now when they ask a question on a body, it has to be a targeted body asking a specific question. Then 2017, this is an ECI question. To enhance the quality of democracy in India, the ECI has proposed electoral reforms in 2016. What are these suggested reforms and how far are they significant to make democracy successful? As I've told you before, the question is never about the CAG, about the ECI. The question is about what does ECI do to make democracy and elections better in the country. So you will see questions combining ECI with MCC, ECI with elections, ECI with electoral reforms. So when we do all of this under a larger umbrella of electoral governance, where we look at the laws, we look at the institutions, we look at electoral reforms, we look at party politics and voter behavior all together in one ecosystem, it would therefore make a lot more sense than it would have otherwise. So the context was obviously in the question, it is about simultaneous elections and so on and so forth. But this was the question that was asked in 2017. Now there was one more question which was asked in 2017, and I'll beg your attention here. This question is now for the first time, they've asked a body-based question in vulnerable sections. So the question is this: is the National Commission for Women able to strategize and tackle the problems that women face both in public and private spheres? Give reasons in support of your answer. So this question is about, is the NCW doing a good job? Now the reason this was asked in 2017 is because 25 years to NCW, so there's an anniversary year right there, and 2, there were inputs that were given by the National Commission on Women on triple talaq, which was on the triple talaq case, which was sought by the Honorable Supreme Court, and also on the eve of New Year's in 2016 in Bangalore, there were widespread molestations and harassments that were reported at the Central Square in Bangalore, which is generally called MG Road, which is something that some of you from Bangalore would be familiar with. But this was a larger functional question on the National Commission for Women, and this would therefore be tagged under social justice and vulnerable sections. Now, in 2018, this is what is asked. Now, in 2018, the question was whether the National Commission for Scheduled Castes can enforce the implementation of constitutional reservation for scheduled castes in religious minority institutions. A very specific and targeted question, which we've sort of partially referenced in minority rights also. And this was asked for 2 specific reasons. One was the contemporary context, where Aligarh Muslim University and Jamia Millia had denied scheduled caste reservation to admissions for admissions to their universities. And second, the article which changed and created the National Commission of Scheduled Castes, so it has been there differently under a name, was 15 years in via the 89th Amendment of 2003. And nonetheless, it gets tagged to social justice and vulnerable sections. So again, there is a yearly anniversary calendar to always remember. In 2018, you get another question, and keep in mind, if they've already asked you a question on functions, now for CAG, they would ask you a question on appointments. The CAG plays a very vital role, has a very vital role to play. Explain how this is reflected in the method and terms of his appointment, as well as the range of powers he can exercise. Now, there were 2 reasons why this was asked. One was, of course, the CAG had given a very strong objection to Kerala floods that had happened, and 2, the GST and the CAG had announced undertaking audits pertaining to the implementation of GST. Therefore, again, tagging GST to that context. Also, if you would remember at that time, there was a person who was being retired from the CAG and was to be prohibited from taking any government employment, but had taken something such as the Banking Bureau chairperson and so on and so forth. And we'll discuss that eventually. Now, 2018 had another question, which was again about the Finance Commission. How is the Finance Commission constituted? What do you know about the terms of reference of the recently constituted Finance Commission? Discuss. A straightforward, direct question on the 15th Finance Commission, and then they'll go back to the 14th Finance Commission for reasons best known to them. Again, Finance Commission therefore gets tagged to bodies directly. Then, multiplicity of various commissions for vulnerable sections of the society leads to problems of overlapping jurisdiction and duplication of functions. Is it better to merge all commissions into an umbrella human rights commission? See, they're asking extrapolatory function-based questions to institutions in and around human rights and vulnerable sections. This was asked because of 25 years to NHRC. So A, the NHRC Act, and second, NHRC being set up as a body. Similarly, NCW Act and NCW as a body. 2 different years to always follow. Now, in 2019, there was a specific question on Attorney General. This was asked because of the Rafale case and, of course, certain statements that were made, which again gets tagged to bodies, not important for Mains 2024. The Attorney General is the chief legal advisor and lawyer of the Government of India, not just the person who's currently the Government of India. Again, could be answered thematically. There were enough articles about this in the editorials of that year. In 2020, there was a question on the RTI. The question was, recent amendments to the Right to Information Act will have a profound impact on the autonomy and the independence of the Information Commission. Therefore, our original hypothesis of doing right to information and CIC together in good governance, anti-corruption as a theme makes a lot more sense. The context to this, of course, are the recent amendments where tenure and all of those things were moderately changed, making them greatly in favor of central intervention. There was another question which was asked in 2020. The question was, what steps are taken for the constitutionalization of a commission? Do you think imparting constitutionality to the National Commission for Women would ensure greater justice and empowerment in India? Give reasons. This was asked because of 20 years of the NCW Act and therefore gets tagged to social justice and vulnerable sections. Now in 2021, they go a year back and they ask you Finance Commission recommendations because of end of tenure and review. How have the recommendations of the Finance Commission of India enabled the states to improve their fiscal position? So our original understanding that there are 3 questions that are asked on Finance Commission stands to be valid. And then you finally move to the last set of questions. There's one more question that comes in 2021, which is, though the human rights commissions have contributed immensely to the protection of human rights in India, yet they have failed to assert themselves against the mighty and powerful. Analyzing their structural and practical limitations suggest remedial measures. Now, the reason this was specifically asked is because of 15 years to a major amendment that happened to the Human Rights Act in 2006, but otherwise also a general theory question, which is effectively about the structure and the functions. So going back to our original hypothesis that vulnerable sections, you will get questions on their appointments and you also would largely get questions on their functions, therefore gets tagged to social justice and vulnerable sections. Now in 2022, because of 5 years of the completion of the National Commission of Backward Classes, the constitutional body, and almost 30 years, 29 as a statutory body, discuss the role of the National Commission of Backward Classes in the wake of its transformation from a statutory body to a constitutional body. Gets tagged in vulnerable sections and social justice. In 2022, you get an ECI question combining ECI and Model Code of Conduct. To discuss the role of ECI in the light of the evolution of the Model Code of Conduct. So when was it first? It was first introduced in the 70s. There were some changes that were made in the 80s. The most recent changes that happened in 2014, and so on and so forth. The reason this was asked in 2022 is because A, it's a standard theory question. 5 states had gotten into elections in 2022, and there were severe cases of MCC violations that were being reported, and it was all over the newspapers. So therefore, Election Commission and MCC again become remarkably important this year in 2024. In 2023, they've asked you a regulatory question. This is because of the Paytm-Google conflict in terms of anti-competitive behavior. Discuss the role of the Competition Commission of India in containing the abuse of dominant position by multilateral corporations in India refer to recent decisions. Now, abuse of dominant position, as we understand it to be, is a categorical term that is mentioned in the Competition Act. And therefore, what one must understand is this is more of a legal question as opposed to it being a question which is largely institutional in nature. And once we cross reference it, we therefore understand this is my syllabus. I would largely be focusing on constitutional bodies in this lecture. Understand two constitutional bodies in theme number 10, CAG and the Finance Commission of India, and then the rest of these bodies get bifurcated into the remaining themes of governance, social justice, and so on and so forth. And that is how you would effectively be preparing a larger area of what is called themes.